This is almost a year now.
Lordship, matter relates to applicability of new pension scheme or old pension
I
scheme.
understand, but
Lordship, on this similar issue, Lordship, coordinate bench passed one order also, recently passed one order. We are also going through that judgment, Lordship.
no, I understand, but we try to understand the predicament of the court also. It's more than a year. I can't keep it for so long.
Lordship will take up on 16th, Lordship.
Next week, AG is not there.
But here's some difficulty, Lordship. Today morning, I talked to him, Lordship. He said it will be convenient if Lordship agrees on 3rd week, Lordship.
All sides are duly represented. Therefore, adjournment is made on behalf of the Learned Advocate General by Mr. P. Nayak, Learned Standing Counsel for the BTC.
I'm assisting him, Lordship.
As a Learning Counsel assisting him. Having noted that the matter has been kept parted for a long period of time, it is made clear that if the the hearing cannot be taken up on next date of listing, the court will be inclined to raise the matter from being parted. Next one. Based on 16/5/2023.
My lord, may I pray that matter instead of hearing, if your lordship pleases, can it be taken up in the admission hearing column, my lord, so that matter will come up in the higher top of the list, my lord?
Which one?
Instead of hearing, if your lordship pleases to take it up, take the matter in the admission hearing column, my lord, then probably matter will list on the.
Item 16.
Not but this series, my lord.
Oh, you just make a mention on that, they will take it up. Otherwise,
My-
I can
my lord.
take it up.
Obliged.
May I pray, Lordship? Lordship, in item number 30, I have filed an affidavit on behalf of the respondent number 2. May we permit it?
May it please your lordship, similar prayer lordship in item number 30, respondent obliged.
Lords, I'd like to mention item number 42 with the consent of the respondent. Lords,
It is a review
unfortunately,
petition.
yes, Lords,
Why?
so
It's not a review.
Lords, my senior Mr. Satyan Sharma is not keeping well, Lords. Therefore, Lords, I seek a short accommodation, Lords, 1 week or 2 weeks, Lords, whatever is inconvenient.
Consent of the other side. The counsel for the petitioner prays for adjournment on the ground that Mr. S. Sharma on counsel. Leading senior counsel leading him is unwell. Based on fixed date after 2 weeks. Fixed date after 2 weeks.
Grateful.
Yes. Next.
May it please your lordship.
Yes.
Lordship, I beg to mention item number 38 of the daily list, lordship, with the consent of the other
Yeah.
side.
Item
38, lordship. With the consent of the other side, lordship, as my senior is out of station, lordship.
okay. List of the police is straightforward and counsel for the petitioner.
Obliged. Please leave your lordship. Lordship, I beg to mention item number 4, lordship.
What is 2018 matter? Why you want an adjournment?
Lordship petitioner already got the relief, lordship.
Okay, you want the matter to be closed?
Lordship.
Okay, both sides are duly represented. Miss,
I am not there, lordship. I mean, I wanted to mention other matter, lordship, not in this matter.
no, she's praying for closing the matter. I said all sides are present. I'm not recording any names. Your name?
F interest.
Mr. F. Intas, Grand Counsel for the petitioners, upon instructions, submits that the petitioner has got the relief and does not want to press this matter. So accordingly, matter stands closed on, closed as not pressed.
Lordship, I wanted to mention item 33 of today's daily list, lordship. Lordship,
Why adjournments and review petitions?
Lordship, only for today, lordship. some difficulty on the part of my senior lordship. It may be taken up in the next week, lordship, if possible. I have taken the consent of the review petitioner, lordship.
Okay, consent of the other side, Mr. M. P. Sharma, counsel for the respondent, please for examiner, there is allowed, respond. You have to date.
Lordship, please. Obliged, lordship.
Continuous, person. Have the council in item number 30 present? There is a personal appearance.
Yes.
Who's for the petitioner? Who's for the petitioner?
PJ Saikya, learned counsel, PJ Saikya.
Will you wait for some time? Let him
Yes,
come.
I may be allowed to inform him, my lord. Inform him.
Daily list item 1.
May please, your lordship.
Yes,
Lordship, on the earlier date, my lord has directed me to get instruction from my client, my lord, that whether he have participated in the selection process or not.
yes.
My lord, at this moment, I don't have any instruction, my lord, as I am unable to contact him. So further, 1 week time may be allowed, my lord.
Okay. Yes. The learned counsel for the petitioner prays for further 6 weeks' time to respond to the query posed by order dated 21/4/2023. List after 2 weeks.
I'm highly obliged, man.
Lordship, if it is not inconvenient, may I pray for a date, lordship?
After 2 weeks, give a date.
18/5.
18/5.
Much obliged.
Yes, item 2.
Item 2.
My lord, in this matter, R. Mozumdar will appear, my lord. He earlier dealt with the review petition, one review application was there. So, my lord, he will appear here, my lord.
After some time?
After some time, my lord.
Okay. P.
Now item 3.
Item 3.
May I please, your lordship?
Yes.
On last occasion, the newly incident, my lord, my senior. That the NCQ was asked to some direct.
Yes. Mr. Islam, you have it? Mr. Alam?
My lord, I have received the instruction, my lord. Your lordship. In the first page, your lordship may found the application code.
As per your regulation, they are permitted to start the course when they get the application code, right?
Yes, my lord. Since they have applied in the year 1996, my lord.
But in 1998, you refused.
1998, we have refused, my lord. But initially, process taken place for at least 2 years, my lord. So initially, they have permitted for 1999, 2007
So
session.
therefore, the B.Ed degree by the college in 1996 was lawful.
Within the extended period, my lord. That your lordship already decided in the judgment of Shopon Kumar Sinha, my lord. In that case, I may be allowed to file an affidavit, my lord,
Yes,
so
you'll have
that
to.
it will be bring on record, my lord.
You will have to. All sides are duly represented. Mr. I. Alam, the standing counsel for the NCT, has submitted that he has received instructions pursuant to order dated 14/3/2023. So accordingly, the NCT within bracket respond number 6 is permitted to file an affidavit to bring on record the stand of the said respondent on record. We give you 2 weeks time.
3 weeks, my lord, since from Delhi and they have posted me and then
Okay. As paid for list after 3 weeks. Instructions I'm returning.
My lord, with due respect, my lord, can I get a date, my lord? For the next.
You make a prayer because all matters are being adjourned.
Must oblige.
Make a prayer for mention.
My lord. Oblige, my lord.
Item 5 to 7.
Lord, here I need 1 week time to take instruction from my client office. So some of them have informed that they have got relief. Some of the petitioner got relief. Therefore, Lord, I need 1 week more time to take instruction. from my client.
They got relieved or they got relief?
Relief,
Okay.
some of the petitioners.
Okay, also duly represented. The learned counsel for the petitioner submits that as per his instructions, some of the petitioners have got the relief. And therefore he pays for and is granted 2 weeks time to obtain instructions. List after 2 weeks. Uh, Mr. Rava, you have instructions? No.
I don't have instruction.
Item 8.
So Pegu, you got instructions.
I have got the minutes of the 17/7/2017.
Please pass it on.
The claim has been rejected on the ground of late submission, my lord. After almost 3.5 years. The government employee died on 13/4/2011, and the application was made on 5/11/2014.
Yes, Mr. Chaudhary.
My lord, in fact, my lord, the in the ground, my lord, there are two grounds have been set for rejection of petition.
Yes.
One is late submission of the application, and other is, my lord, the violation of clause 1 of the my lord, the OM, my lord, 2015. These are the two grounds. And so what the first ground is concerned, my lord has already seen that it is within time. It is within time that my lord will find at page 15.
15.
On page 15, my lord. That was the application, my lord, on 26/9/2011. So it is within time. And based on this, my lord, he came to this honorable court, and this honorable court, my lord, passed an order that my lord will find at page 19. And in that order also, my lord, there was a talk of first application that was to be placed before the DLC. And they did not raise any objection at that point of time also. That it was within time. They came to this honorable court. This honorable court passed an order mentioning the date of application of that first application, my lord. So there is no question of late submission. Of course, my lord, there's some reminder petitions have been filed, and they have taken into consideration the reminder. But they ought to have seen the first application. Subsequent several applications have been filed. As because the first application was not acted upon.
You are saying that page 15 is your initial application is 26/9/2011.
My lord.
It's not in 2014.
No, my lord. That was a reminder, my lord. Several reminder petitions have been filed. We have also annexed some of the.
Be that as it may, my lord, even if it is.
And so far, my lord, the second ground is concerned, my lord. This has already been stricken down by this honorable court, my lord. So for the second ground is concerned, my lord, that there was a violation of clause 1 of the OM, my lord. That is, that a person is, if he is entitled to get the benefit of the compensation appointment, my lord, that his father or mother, their service is to be remain, balance service is to be remain for 3 years. That was the clause set forth. And because of that clause, that is the second ground. And this particular clause has been stricken down, my lord, by this honorable court. Discussing various, my lord, the judgment of the apex court.
If I'm not mistaken, that was not the ground of rejection. That minimum balance period of 3 years, that was not the ground of rejection. And that is in terms of clause 1 of the OM dated 1/6/2015. But this case belong the date of the competent law is in 2011, my lord. So in terms of Haziran Nasa, my lord, there has to apply in a proper format.
No, but if he has applied before DEO on 26/9/2011,
My lord,
ask the elementary education to find out.
my lord.
He says that you have a copy of the petition.
Yes, sir.
Please come to page 15. The block elementary education officer
My lord.
appears to have forwarded this by memo number 2911 dated 26/9/2011. Just find out that.
I'll get my instruction.
Also is a duly represented. Pursuant to order dated. Uh, 4/4/2023, Mr. G. Pegular, government advocate, has produced a copy of minutes of the meeting of district level committee, Karimganj, held on 17/7/2017. Next paragraph. from copy of purported application dated 26/9/2011 within bracket annexure D. It is projected that the block elementary education officer, South Karimganj, had forwarded the application of the petitioner to the district elementary education officer Karimganj, vide memo number 2911 dated 26/9/2011. First off, the learned standing counsel for the elementary education department, Mr. A. Fukan, standing counsel for elementary education department, shall forward a photocopy of the said annexure D of the petition to the block elementary education officer and the district elementary education officer Karimganj. First will be South Karimganj, block elementary education officer South Karimganj and district elementary education officer Karimganj. So as to enable the said two authorities to inform the court as to how they have dealt with the application of the petitioner as forwarded by the block elementary education officer. Next, learned standing counsel for the elementary education department shall also send a downloaded copy of this order to the said authorities to elicit information. Next, list on. After 4 weeks, give a fixed date. I'm giving you sufficient time, 4 weeks time. The instructions produced by the learned government advocate is returned to be produced on the next date.
31/5.
I'll utilize.
Item 9.
Lordships, may I just interrupt, madam? I apologize, madam. Item number 8, which Lordship has passed an order, madam. That I am informed that he has already been appointed as an assistant teacher. The petitioner. Perhaps that information he can acquire, madam.
Is it?
Yes, madam. He has been appointed as assistant teacher in 413 number Satpa Kusum LP school and joined on 24/9/2022.
Okay.
After long.
His compassionate appointment.
I don't have.
We'll just take an information on the next date, madam.
Just change that order. What says it? Mr. R. Mazumdar, and standing person for the elementary education department, has submitted that as per instructions received by him, the petitioner has already been appointed on compassionate ground in number
413 number Sapta Kusum LP school.
SAPTA KUSUM.
KUSM, Sapta Kusum LP school and joined on 24/9/2022.
This one. Next, accordingly, the Mr. M.H. Chaudhary, learned senior counsel for the petitioner, shall obtain instructions from the petitioner. This after 2 weeks.
Obliged, madam.
You just write Mr. A. Fukan for the secondary elementary education department and CG Pegu government advocate are present. CG Pegu government advocate has produced copy of minutes of so which has been perused and returned. Oh, item 9. Yes.
Smaller. Entry noted is at page 24, my lord.
Yes,
Your lordship kindly see the impugn order. Sir, I am directed to say that the government of Assam is pleased to amalgamate the following schools with Ayabari High School under the Shiksha Chapter, a scheme for the amalgamation of schools which are located on the same campus in pursuance of the government office memorandum dated so and so, subject to the condition that no additional posts are created and no additional financial implications will occur. Now the name of the school is, my lord, Betna Defali Milan High School. And the next school is Betna Defali Milan ME School. Both these schools are in the same compound, but my lord, Ayabari, it is directed to be amalgamated with Ayabari High School. The Ayabari High School is 15 kilometers away. Lordship kindly see, I have made this statement at paragraph, my lord, paragraph 14. It is not in the same campus. Lordship kindly see, paragraph 14. Lordship.
Para,
And there are 14 melon. That unless the Honorable High Court interfere with the arbitrary and malafide impugn order, the further Bengali para ME school shall suffer either loss and injuries, which cannot be compensated in terms of money. Further, a mere perusal of the impugn order dated 19/1/18 reflects that the respondents were pleased to amalgamate the further Bengali para ME school with the and the SMDC with the Ayabari High School. Whereas no, there is no such high school in the same campus. There is no school. Ayabari, there is no such high schools. Now, Lordship will kindly see the clause number, memorandum of the clause number 10 is violated by themselves. Memorandum is violated page 16 and the relevant portion at page 19, madam. Page 19, Lordship, paragraph clause 10. Clause 10, madam.
now, what is the enrollment in this Bengali Para ME school?
Bengali para ME school and Bengali para high school are in the same campus.
No, that is okay. I'm asking you, what is the enrollment in this?
There are 368 students, madam, in the Bengali para high school, ME school. I have annexed it.
Where is that?
368 students, madam. Lordship will kindly see page 7, paragraph 7. That there are 368 students in the said Paladar Bengali para ME school in class 8, 80 students.
Yes, Mr. Fukan, you have not controverted any statement here.
They did not controvert me.
We allow this writ petition then.
My lord,
We allow this writ petition.
here, my lord, you have to, my lord, file our affidavit.
But the government is not, what you call, I think they have taken a decision not to contest cases. If for 5 years you don't contest,
My lord,
what is the guarantee you will contest? I can make them, I can compel them to contest. I'll impose a cost of 5 lakh rupees if they don't file their affidavit within 5 days.
my lord will,
5 lakh rupees, 5 days. Or you call them at 2 o'clock. Let the officers be present at 2 o'clock. They won't give you instructions unless we compel them.
my lord, may give us a last chance, my lord, we'll be filing it, my lord. Actually, my lord, the matter has come after a long time, my lord. We also
See,
were not there, my lord.
that is for you to suffer. Why should the petitioner suffer for that?
No doubt, my lord, it's a 16 matter, my lord. I'll ensure this time, my lord, since I've appeared for the first time, my lord, this matter, my lord.
I'll ensure that, my lord, will be filing an affidavit. Kindly, my lord, may consider, give us one last chance.
Mr. R.C. Saikian and counsel for the petitioner. Mr. A. Fukal is standing counsel for the Elementary Education Department, placed for some time to file affidavit in opposition. Next para. The petition was filed on 3/8/2018. And notice of motion was issued by order dated 21/9/2018. So the projected case of the petitioner is that although two schools are sought to be amalgamated by impugn order dated 19/1/2018, but Bhola Jhar, BHOLAJHER, Bangali Para High School, Tamulpur, and Bhola Jhar, Bangali Para ME School are not located in the same campus. And that where is the statement, Mr. Saikia? You said it was 24 kilometers. Where is that?
I have very high school, my lord.
No. Where is the statement? You said that you made a statement. It is 24 kilometers away. Where is that statement?
My lord, there's number of students.
No. You say that it is not in the same campus. Where is that statement?
Yes, Ayabari High School is not in the same campus. Paragraph, my lord, last time. Paragraph 14, my lord.
The two schools are 15 kilometers away. And that there are 368 students in at the relevant time. There were 368 students in Bhola Jhar, Bangali Para ME School. And how many students are there in the other school?
Voladar ME School, Voladar High School, then Ayabari High School. But my lord, in the second sentence, page 24. Used to amalgam following schools with
No.
Ayabari High School,
Mr. Saikia,
my lord.
how many students are there? I'm asking you.
368 in our school.
In one school, in the other school?
Other school, my lord, I do not know, my lord. Page 15 may be kindly seen.
No, we are not concerned with that. You see, the requirement is that if one school is having a lesser number of students at any school, they'll have to be compulsorily amalgamated.
Cross then may be kindly seen of the memorandum.
No, that is okay. It's a nearby school.
We are concerned with the ME school. Kindly, my lord, if a ME school has 4 enrollment, less than 15 students in each class, then the ME school may be merged with the nearby high school. So they have to file an affidavit. How many students are there in the high school?
Oh, okay. In the ME school, so-and-so ME school, there are 368 students, and therefore the said school is not covered by the office memorandum dated 22/9/2016. Stop. Next paragraph. The state respondents are put to notice that if no affidavit is filed within 10 days from today, the court would presume that the respondents have admitted the case of the petitioner, and then by invoking the doctrine of non-traverse, the writ petition would be allowed on the next date. Full stop. Next paragraph. You make it, no, not 10 days, you make it within 12/5. 12/5. Based on 17/5/2023.
In this matter, actually, the secretary department's role will be more important because it's an amalgamated case and they're challenging the order dated 19/1/18. So, my lord, more than us, the elementary, the secondary will be required. Their views will.
No, I've said, I think, I don't say elementary.
Secondary.
Second. You said all the respondents
All respond.
are put to notice. This is in BTAD area.
Plus, my lord, they are challenging Annex 5.
Mr. Rava, you will be appearing in the matter for BTAD. This right there is A. Pugan for the Elementary Education Department, Mr. R. Mazumdar for the Secondary Education Department, and Mr. S. Rawat and the Standing Council for the BTC.
Yes.
I'm putting all of you to notice within 9th, within 12th affidavit. If it is not filed on 17th, we dispose of the repetition. Item 2.
Time being item 2.
My Nikki? Oh, may I please your losses. In
Yes.
this case, my lord, respondent filed one review, my lord, which is allowed, not partially allowed. So my case is covered by this review, my lord.
Originally, for such kind of petitioners, there was an order from this honorable court saying that they should all be regularized, keeping in view the judgment of Uma Devi, since they've been working without court orders for quite a long time. In that judgment, there was a finding that they were appointed against sanctioned posts. But while trying to regularize them, department realized that they were not appointed against sanctioned posts, but were appointed, but were excess appointees. And therefore, we moved a review. Now the matter has been sent back to the department to see that if they were against sanctioned posts, the regularization would follow. We have to find out the status whether they were against sanctioned posts or in excess of sanctioned posts. If these petitioners are satisfied with this order, that inquiry can be done.
Para 15 lawsuits, kindly peruse. Appear who is in the secretary, whether they will working as against section post or not.
They were appointed.
Question as to whether an employee.
So,
18
Ms. Devi,
lawsuit
you
kindly
want to
peruse.
subject yourself to an inquiry by the authorities.
Yes, my lord. And 18 it is, my lord. Para 18 it is stated. That individual petitioner make an application before the secretary to the government of Assam in the secondary education department, stating in detail that the dates of
Okay.
appointment, name of the institution where they were appointed, to procedure adopted for such
Okay.
appointment, the post of which appointment were made, as well as the post creation.
Ms. K. Devi, learned counsel for the petitioner. And Mr. R. Mazumdar, learned standing counsel for the Secondary Education Department. Appearing for
High school, secondary.
all the respondents. Next para. The case of the petitioner is that he was temporarily appointed as grade 4 employee in the Tengabari, TENGABRI, Janata Vidyapit Higher Secondary School on 1994 by the Director of Secondary Education Assam. Within bracket respondent number 3. Full stop. The petitioner received salary up to 1996. And as the payment of salary was stopped, the petitioner had approached this court by filing, where is your previous order? Where is the previous petition order?
Lordships,
Previous, you said that your previous writ petition was filed. Where is the order?
that is, my lord, page 44,
Page,
WBC number 4749/2012.
'44.
44.
But this is not your writ petition.
Yes, my lord, this is the,
No, there is a statement in your
Yes.
synopsis that you approach this court.
yes, my lord. this is
Which matter?
One point, that salary of the petitioner's status. Petitioner approached this honorable court. 4689/90. My lord, I have mentioned in para 4. 4689/99.
In topic of salaries, the petitioner approached this court by filing a writ petition which was numbered as WPC 4689 of 1999.
Yes.
So as per the statement made in the writ petition, the writ petition was disposed of by this court by directing the respondent authorities to refer the case of the petitioner before expert committee.
Para, my lord, page 26, there is a para-wise comment. For 4689/99 filed by the Siri Krishnakanta Deka, Gate 4, Tangabari the High School. Inspector School wrote a letter to the director.
Is projected that
And he paid up to June 1996.
the authorities took steps for filling up of 145 grade 4 posts. And accordingly, the petitioner and others were directed to appear before the selection board for regularization of his service. Full stop. As no further steps were taken for regularization of service of the petitioner. The petitioner has approached this court for a direction upon the respondent authorities to regularize the service of the petitioner against existing vacant post of grade 4 post in the school of in the Tengabari Janta Vidyapit Higher Secondary School. Next paragraph. The Lawyer Counsel for the petitioner has submitted that in respect of the employees who were appointed in vacant sanction post, orders have been issued by this court in various writ petitions to regularize the service of such employees. Full stop. In this regard, reference is made to the orders passed in WPC 7485 of 2015. Full stop. However, the education within bracket secondary bracket was department moved a review petition before this court, which was registered as review petition 52 of 2022. Seeking leave of this court to examine if the employees were appointed in a vacant sanction post and as to whether such employees were continuing in service without the aid of any interim order of the court. For which there was a necessity to make an inquiry and arrive at a factual conclusion. So accordingly, this court by judgment and order written 9/8/2022, passed in review petition 52 of 2022. Permitted the respondent, the respondent, the education within the secondary department to make an factual inquiry as to whether the employee can be said to have been appointed against a sanctioned vacant post.
If the understanding took place for inspection.
If at the time of the appointment vacant sanction posts were available in that particular organization where the concerned employees were appointed. And to arrive at an individual factual satisfaction and permitted the person concerned to file an individual application before the Secretary to the Government of Assam in the Secondary Education Department, stating in details the dates of appointment, comma, the names of the institutions where they were appointed, comma, the procedure adopted for such appointments to the posts to which the appointments were made, as well as the post creation number. You omit that, you say the following directions are issued. Then para 18 to (22) is separate order. Next para. In light of the decision of this court in the review petition 52 of 2022, comma, the learned counsel for the petitioner submits that the petitioner is also ready and willing to subject himself to an inquiry as to the manner in which the petitioner was appointed. To this head, offer, comma, the learned standing counsel for the Secondary Education Department has no objection. Same thing within 3 months.
So, my lord, if Lordship would just make my reference to page 43 of the repetition that I have pointed at page 43 on the
Page
43 of the repetition. But this indicates that he was appointed in excess of the sanction posts. That I have just pointed it out.
No objection to it, and it is submitted that as per Annexure 17 to the petition, it appears that the petitioner was sanctioned in page 43.
45, 42, my lord.
43. 45, 42,
42.
42 losses.
Where is the mention that he is extra?
My lord, the name of the petitioner appears at serial number 1, serial number 1, subserial 2, Krishna Kanta Deka.
Yes.
So and therefore, after both the point number 2, both the above mentioned grade 4 employees have been working in the school. So their lordship will find at serial number 1, government has indicated 2 numbers of grade 4 employees who were appointed in excess than the sanction scheme. That sentence. And serial number 3 says list of excess appointees. He is at serial number 2 on the table.
No objection.
And therefore we have to verify.
As because from the contents of Annexure 16 to the petition, which is the information submitted by the Inspector of Schools, Darang, dated 16/9/2011. The petitioner appears to have been appointed in excess of the sanction post. Next, be that as it may, as the petitioner as the learned counsel for the petitioner has offered, has submitted that the petitioner has offered to subject himself to scrutiny, comma, the verbal prayer made by the Run Council for the petitioner stands allowed. Next, accordingly, this the petition is disposed of by granting liberty to the petitioner to submit his application, giving the details as mentioned in para 18 of the hearing before a quoted order passed in review petition 32 of 2022, and to submit the same before the Secretary to the Government of Assam, Secretary Education Department. Next para it is provided that on receipt of such application, the office of the Secretary, Secondary Education Department shall give a proof of receipt of such application to the petitioner. Full stop. The exercise of factual verification shall be done by the Secretary Education Department within an outer period of 3 months from the date of receipt of the application, to accompanying with certified copy of this order. Next one, the petition shall also furnish email address and or phone number with WhatsApp facility to enable the Secretary Education Department to communicate his finding to the petitioner. You give your email address or WhatsApp number, they will communicate it to you.
Highly obliged.
Obliged, madam.
Please review the evenings.
Yes, personal appearance item 30.
Item 30.
My lord, here in this case,
Yes,
by the order dated 3/4, my lord,
yes,
I was pleased to direct the personal appearance of respondent number 2 and 3, my lord.
yes,
They have filed a short affidavit also, my lord,
yes.
wherein respondent number 3 has retired on 31/3/2020 itself. 31/3/2020.
Just a moment.
Right?
Respondent number 3,
Yes, retired on 31/3/2020.
31/3/20.
Yes. And my lord, respondent
During-
number 2,
Just one by one.
yes,
During this period,
yes,
till 31/3/2020, what
Yes.
steps was taken by the respondent number 3?
yes, my lord. If your lordships comes to the previous affidavit that has been filed on 11/3/2019, my lord,
11/3/2019.
19, that was been
Just one.
filed by the secretary,
Just a moment, let me find
Yes.
out.
Robinson Musahari, my lord. Deed and secretary has filed this affidavit.
Yes, I
Yes.
got it.
If your lordships go to the two annexer itself, my lords, it speaks in volume, my lord. At page 4. This is A.K. Bottomale, Deputy Secretary, Board and Territorial Council to the Director of Education. In enclosing here is a copy of Honorable High Court's order dated so and so, passed in read petition number so and so, received from the Eastern Register so and so Guwahati High Court. I am direct to request you to comply with the order of the Guwahati High Court as sought in connection with the content of the representation. Now, my lord, next page, my lord will kindly see on that very basis, the respondent number 3, my lord, the lead and director immediately, my lord, wrote to my lord, the Deputy Inspector School of Nalbari to hand over all the records pertaining to this to the Commissioner and Secretary Education Department, Elementary Education Department, Government of Assam. And this record is pertaining to Nalbari district, my lord, undivided, wherein this appointment 97 prior to my lord, BTC came into existence. BTC came into existence, my lord, 17/10/2003, my lord, by way of a constitutional amendment. And this respondent was appointed in 2007, my lord, as director. of
No, it's okay, but Mr. Bhuya,
Yes,
you see, these authorities are high authorities of the BTC.
my lord.
The letter written at page 4 is by the Deputy Secretary,
Yes, yes,
BTC.
yes,
Second letter is written by the Director of Education.
yes,
You see, if a subordinate officer in the rank of inspector doesn't comply,
yes.
just see my situation.
Understood,
I put myself there.
absolutely, my lord.
I issue a direction and the subordinate officers say that, okay,
My lord,
the director, let him do what he wants.
my
And
lord.
the director will act like a mouse,
Absolutely,
go behind the bed and sleep.
Right.
This is something which is unheard of in administration.
my lord,
If they can't take a decision, they should be out.
my
They
lord,
should resign voluntarily and go out.
my lord,
Give young generation a chance.
my lord. And this is, my lord, so far his jurisdiction is concerned, it is outside his jurisdiction, that is appears
That is
in
okay,
paragraph
but-
6 also.
But how can someone tolerate, a high official can tolerate insubordination?
Absolutely, my lord, that should not be, my lord. That's why these litigations are, my lord, because
Uh,
court
I think-
orders are not executed.
2016 to 2020,
Yes,
for 4 years, he is sitting idle.
my lord.
Contempt is made out.
With all respect, may I submit here, my lord? So far, receives of the court's orders copy to the register.
You will find if you sit for 10 minutes in the bench taking up MSCT matters, you will find very surprisingly a stand taken in most of the cases by the insurance that they routed the claim from table to table.
Yes,
So in one of my orders, I have said that if the insurance company tries to hire the stadium and puts up tables after tables and let all the what you call claim move from table to table, I think if Nehru Stadium is hired,
absolutely right.
for 1 year, nothing will happen.
Nothing will happen, definitely.
So is it the same procedure? Because if the authorities don't take action, why contempt? They should not be punished.
My lord, here is a, my lord, with regard to this, my lord, person concerned, respondent number 3 is concerned, director, my lord. And there may be correspondence in between also, my lord. We are not privy to it as of now, because I have retired way back, my lord, in 2020 itself.
No, but for this 4 years,
And today, the affidavit that we have filed in, my lord, there are,
we'll permit the officer who has retired on 2020.
my lord,
By virtue of the orders of the court, they will go to their office, they will inspect all the files. The authorities who don't allow them to inspect the files, it will be reported to this court and find out the answer within a week. What they have done in this 4 years.
my lord, today's affidavit, my lord, I have filed it, I will kindly see to it, my lord.
Yes.
Now, my lord, with regard to this, my lord, we have annexed, my lord, the documents, because on 29/4, my lord. Yes.
Just a moment, just a moment. This is a contempt of which order?
My
Order
lord,
passed in WPC 2147,
yes.
2147.
No, in 1953 of 2016.
1593.
Yes.
Okay, just a minute.
And order dated 21/3/2016.
Where is the copy of the order?
If it is annexed into the, in the contempt petition as annexure one.
Annexure 1.
This order has been complied with, my lord.
Is complied with?
Yes.
Then why is the contempt?
Subsequently, it has been complied with, my lord. Yes, government is.
I appear for the then Commissioner Secretary, my lord, respondent number 1.
Just a moment, I'm just trying to understand this order. The matter should be placed before the appointed committee, and the committee within 4 months thereafter shall consider the case of the petitioners
Yes.
regarding their arrears stipend from May 97. As directed the court in its common judgment, there is so past instruments so. The petition shall be served a certified copy. The respondent should intimate the petitioner about the outcome of the committee's decision. Suppose the objection, the petition stands disposed of. Okay, yes.
The respondent number 1, my lord. I have filed an affidavit yesterday. Now, my lord, he has also retired on 30/4/2021. But my lord, with some effort, we have been able to find out that the matter was placed before the committee, expert committee, my lord. And the expert committee has taken a decision on
Retired on,
27
what is the date of retirement?
30/4/2021, my lord.
Yes.
And my lord, prior to that, he had made his communications, but now he does not have copy of the documents with the records of the file, my lord, that I have stated in my affidavit, my lord. There were correspondences with the BTC authorities asking for reports,
How much was the stipend? Can you tell us?
my lord.
How much was the stipend? Stipendiary amount?
Later it was increased.
900.
Initially 900, well, thereafter 1800.
Thereafter 1800.
Presently, it's 15,000. If I had been given a communication.
No, I'm just
by
trying to
the-
understand. For this amount, how much the business will run? You are making correspondence, no doubt about it. But if people start making, officers start making correspondence,
The commissioner and secretary had.
no,
to call
I
for the
understand.
report.
You just think of something. If I give an example, Mr. Bhuya will understand. Somebody, what you call, is sought to be, say, supposing a house is to be demolished. A citizen's house is to be demolished. Citizen gives a representation, I have all the documents, please don't demolish. And the authorities say that, okay, we'll start the demolition, but we'll hear you. And every day, one letter is written to other department to the third department. In the meantime, the party is out in the street. 500 must come to an end. If people at the highest officer start corresponding,
The report,
then
the report from the documents that the petitioners gave to us with the representation. Those have to be verified and there has to be a report on that matter, otherwise we cannot act on these appointments normally being the appointments themselves being in question or the appointments being in whatever, for whatever reason they have not been paid the salary. This should have a history which has to be verified at the field level.
you learn something from the post office. If they can't deliver a letter, they return it to the sender. If you don't get an answer, can the correspondence and come anything can lead to an end? The officers will find so much of difficulty to wake up, go, but you see, when people demand, the same officers run from school to school, do the exercise, sit with the, what you call, grateful staff. When something has to be delivered. Supposing today the president says that I'll come to a school in his jurisdiction, you think these officers will stay in the chair and don't stand up? Is it so difficult to pass an order for stipend?
Cases have been rejected by the expert
You
committee.
see, I have to give them a punishment which is prescribed in law. I give them 3 months time to comply and pass an order for sentence. You think everybody will run? I pass a suspended sentence. If they don't deliver, they go to jail. Whether the officers are retired, but these documents produced. I'll hear Mr. Bhuya because you took over. So the document of correspondence, he says that the order has been complied with.
That
But-
defense order is by the expert committee, my lord.
Where is that?
First page is the covering letter, my lord, at page 2 of the report, those will find the petitions.
Now, think of the stipend, amount of stipend involved. And petitions are running from 2000. This is a writ petition of which year? 2016. 16 is 23. How many years? 7 years.
years.
Because Mr. Masudha, I was a trial court lawyer,
My lord.
charging fees ranging from 100 to 500 rupees in a daily appearance. Even if that money was not given to me on time, I was not very happy. Small amounts we used to charge at that time. But even if that fees was not paid, it would not be a happy situation. Not that I was breathless, but still amount which was due was not received. It was not a happy situation. So if somebody has worked and the directors will say that, no, I'll sit in my office, I will not wake up. Somebody will have to come and give me an alarm at 5 o'clock, then I'll go home. From 10 to 5, I'll be in my office, there will be an alarm which will wake me and I'll go home. If that is the situation to deal with the complaint of the citizens. Yes, what is the conclusion?
My lord, at page 2, the report starts, my lord, for the petitioners, and page 3 is the decision of the expert committee.
Yes. The petitioner's case is in which decision?
It's in the tabular form, so petitioners, this is a page 2, it starts, my lord, so they have ticked. That should be fine.
Page 2, yes.
First is the covering letter, then page 1 of the report, page 2 of the
Yes.
report.
Page 2, Mr. Keturam's Swargyari.
Those are the petitioners in Kannada.
Yes.
And lordship will find them at page 3 is the decision. my lord.
Non-sanction post. Those have received grant in aid from the so-and-so and discontinued. Private suspension of the for this matter and This was taken up as a grant in aid school.
Yes, ma'am.
This was grant in aid.
They are non-provincialized schools. Lordship will find clause 3, there is no provision for payment of salary or area salary of teachers appointed in venture schools who have not been appointed against sanctioned posts, have no question of area salary, is contrary to the rules as provided in Assam Elementary Education so and so. The Honorable Court.
So here
has
here
no
you
right-
see, in this, in this decision you are producing,
My lord,
here it says the school has received grant in aid from the authority for a few months and discontinued.
yes,
So once granting aid starts,
It can be discontinued.
is there,
Provincialization is a separate chapter, my lord, when we take over the services of the teachers and we continue to give them salary throughout their career. And once they retire from their post, we can-
you have a
but
copy
if-
of, you have a.
the ad hoc granting aid, lordship will find the word, the ad hoc granting aid, what is that? Ad hoc granting aid, my lord, will come in only that way.
This is not ad hoc granting aid. Page, para one says school received granting aid. Because once the school is,
There is no record in respect of the claim of the petitioners is in connection with their selection and appointment as granting a teacher at Venture LP schools. We don't have records to show that they were
You are reading
selected
where?
and appointed
yeah, you're
as
reading where?
granting aid teachers.
You're reading where?
Para one only I'm reading, my lord.
Reported
There
so-
is
so-
no record in respect of the claim of the petitioners in connection with their
You're
selection
reading,
and
you're reading page 2,
page 3, my lord.
page 3.
My lord, is report of the director of BTC Kokrajhar.
Report of the director, BTC Kokrajhar. There is no record of claim of the petitioners in connection with their
Petitioners in
selection.
connection with their selection and
appointment
appointment as
is granting
granting
aid
aid teacher at Venture School. They were never appointed as teachers in granting aid schools.
This petition is 1593.
Yes.
One nine.
195.
One,
195.
oh, so different record has come. This should be 1593. One,
95.
1953.
It starts Mohendra Das and 51 others.
Oh, no, this different record is here. It's Rubia Khatun, WPC 1593, that is why.
How come you have a 62 petitions?
1953.
How this is when the writ petition is 52? From where they arrived? Lordship will also notice one thing, my lord, the original writ petition was titled Mohendra Das and 51 others. Lordship will find at the contempt petition. Mohendra Das and 51 others. Contempt petition is by Keturan Sorgeri and 63 others. At least, my lord, there are 11 or 12 petitioners who are not connected with this writ petition who are before this honorable court in contempt.
1953.
Yes, madam. At page 18 of the contempt petition, lordship will find the title, certified copy of the order, Mohendra Das and 51 others. Now in the contempt petition, if lordship has, it is Keturam Sorgeri and 62 others.
Yes,
The extra 12, my lord, we do not know.
there may be an answer. In a MSCT accident, when you cross over a hen. You have found, you have heard of those stories. Yes, Mr. Sagia, same story, hen and the egg. One nine five three. 1953 of 2016. Well, I think Mr. Mazumdar and Mr. Bhuyan,
Yes.
for a few days we'll examine the appearance of the respondents and we'll have to hear it. Because the record is not there. You are saying that the number of the petitioners have increased.
Increased.
second part is that the,
They have.
what you call you're saying that there is no record of
Them
the
serving
the
as-
granting aid.
No,
I
they,
think-
them being appointed as stipendiary teachers in granting aid schools.
No, that may not be there, because you see, once there is a school and it is covered by a grant in aid scheme, that means the existing teaching and non-teaching staff, they are all covered.
So
It's
those-
not necessary that the appointment should be post.
that record has to come from the school level to the district level. That record is not with the district level means the school did not give those records. They were not in the schools. For the appointment, for the information of the department itself. To get that granting aid in their name, that stipend which comes to the granting aid. They must have some record of appointment, either in the school or in the district level. That record is not before the
They have
department.
received
But Mr. Mazumdar,
My lord.
although I am looking at that aspect, but in a contempt jurisdiction, I don't have that jurisdiction.
So,
I
here-
can't make that inquiry.
Here what Lordship would like to look into is whether the matter had to be placed before the high power committee. Whether we deliberately did not place it before the high power committee. Whether there was any deliberate negligence on our part in stalling the
Yes.
entire process, whether
Yes.
it has been complied with. And if there was any inadvertent delay,
Correct.
have we tendered our unconditional apology and has the order been complied with at this stage? Normally with the orders passed by the high power committee as in 2023. And there being some record, both the parties might have making a statement that we had tried to find out from the reports and we have placed it. Even in 2021, it was placed before the expert committee, my lordship will find in the report itself. It was sent back to the BTC authorities calling for some more clarification. Things were being worked out. There was delay, my lord. And we can only tender our apologies on that matter, our unconditional apologies. Say on the delay, my lord. Otherwise, the order has been complied with. There is any difficulty on their part with the order itself, my lord, they'll challenge it. Although we have not taken the ground that there were only 52 petitioners and we should not look into 63. There's a contempt petition, we looked into everybody's record.
You're right. It's not that whatever you're saying can be thrown away. But I'd have to have that record, 1953.
Yes, my lord, lordship will
It has
call
to
for
be
the
there.
record.
Records will show, madam, the appointment orders, madam, issued by the deputy inspector of schools, madam, to all the petitioners, madam. I have some
That
documents.
will be
madam.
challenged in the.
Records are there, my lord. It's not that the
Show me that.
managing director,
Should
part
show
of
me.
the other petition, my lord.
Appointment letter of the
Okay.
inspector in school of that. That has to be in the petition.
Appointment letter issued by. the
Okay,
deputy
it's okay. I'll get the petition. But for the time being, I think I'll have to exempt the personal appearance. For Mr. P. J. Saikal and counsel for the petitioners.
Lordship's permission, may I give it, my lord, for number one?
Yes, yes.
I appear for the respondent number one, my lord. And I have filed an affidavit
Okay.
yesterday
Petitioners.
by e-filing.
Respondent number one is.
Pritam Sakya, my lord, Mr. P. Sakya, then Commissioner and Secretary.
Yes,
RCGN was, my lord, replaced by Mr.
He was replaced, okay. He's present today? No.
My lord, he is not present, my lord. I had advised him that since the matter has been complied with, we are filing an affidavit. Lordship's earlier order says that if if there is no further compliance placed before this court, my lord, he is to be personally present.
Okay.
May I take leave, my lord?
Yes.
I'm obliged.
Uh, Also heard Mr. R. Mazumdar and counsel appearing for respondent number one. First of all, it is submitted that the order of this court has been complied with, and in this regard, an affidavit has been filed yesterday. First of all, this said affidavit is not on record. First of all. Next paragraph. Mr. You are Robinson Mushari.
Yes, he's happy.
You are there?
Yes.
No, the gentleman is standing behind you. Mr. Robinson Mushari.
Yes.
The respondent number two is personally present. Along with Mr. M. Das, Leonard, counsel. Full stop. Mr. You are Ravi Shankar Borgari.
Yes.
Mr. Ravi Shankar Borgari, learned. Sorry, the respondent number 3 is personally present along with Mr. A. Bhuya, learned counsel. In respect of number 2, you also write that an affidavit has been filed by the respondent before today, which is brought on record. So it is submitted that the petitioner number 2 had superannuated on 31/3/2020, and that during his tenure he had taken appropriate steps
21.
in the matter.
My lord, petitioner number,
Two, he retired.
respondent number 3 has retired on
But
21.
in fact, he held the post of secretary from till 18/4/2018.
Oh, acha, respondent number 3 is retired.
Lordship, two has also retired. But at that relevant point of time, he was holding the post of secretary and that was till 18/4/2018.
He retired when?
He retired, thereafter he was transferred to different departments and he retired finally on 21/1/2021.
Okay. 31/1/20.
21/1/2021.
Okay, 21/1/2021.
31.
31 should be
31,
31. 31. So it is submitted that he was holding the post of
Was holding the post of secretary
Secretary BTC
till 18/4/2018.
till 18/4/2020,
2018, Lordship.
18.
18/4/2018, yes.
18/4/2018. And during this period, he had taken appropriate steps in the matter. Mr. Ekubhia, you said about respondent number 3, Mr. Ekubhia. The respondent number 3 stated that he has superannuated on 31/3/2020.
Right.
And during the said period, he's taken appropriate steps in the matter. Next paragraph. In view of the statement made at the bar, and upon hearing the respondent number 2 and 3 who are personally present, their presence is exempted. But their personal presence is dispensed till further orders. Next paragraph. It is noted that an incorrect record has been tagged with this contempt petition. So accordingly, the records of WBC 1593 of 2016 be returned, and the concerned section shall tag the records of WBC 1953 of 2016. Be tagged along with this contempt petition. Next paragraph. The learned counsel for respondent number 1 has brought to the notice of the court that, notwithstanding that the order of the court has been complied with, but in the proceedings of WBC 1953 of 2016, there were 52 petitioners, but in this contempt petition, 63, there are 64 numbers of petitioners have been pursuing this matter. Next paragraph. The said issue shall be examined on the next date. Next paragraph. Matter stands adjourned today. As per the registry shall tag the affidavit filed by respondent number 1 on record. List on. Fix after 10 days. 12/5/2023.
Definitely.
Okay, your personal appearances are dispensed with. Spell that. Your personal appearances are dispensed with. 12 along with the records of that. Your-
1953. 195.
Your records you could take back that
I'll do it. I'll take that.
HAPAR committee. That record be returned.
That's fine. So that record, since the respondent number 1 could not have got it officially, now he's retired, I had just placed it on record. It is not there with the affidavit also. Should I place it on record, my lord, from the
I think you have to do it because
secretary, I'll have it, please. Present director, I'll have it, please. Okay,
because without that, we will not be able to close it.
I'll place it on.
Take a short break and come back.
Already shown at the council. They have not looked into the order. Suspend version of the.
Item 10.
Yes.
May I please your lordship?
Yes.
My lord, in this case, impugned order dated 19 January 2018 is challenged, lordship. 8 phase 25 may kindly be seen, lordship. 25, lordship. Page number 25 may kindly be seen, lordship. Annexure 4. This impugned order is challenged, lordship. May I read, lordship?
The same matter we heard some time ago,
Yes, sir.
same matter.
Yes. Similar.
Similar, item number 9, we understand, similar. With one high school, two number of schools are amalgamated.
Okay, same order as in item number. Which was the last item?
Item number
Nine.
9. Okay, same order.
So,
Your name?
Miss Korobi Saikia.
Probably say here, for the petition.
Korobi Saikia.
Same order.
Obliged, lordship. Obliged.
Item 11.
May I please, as your lordship?
Yes.
My lord, I have received an affidavit, my lord, today only, my lord, has filed by the circle officer of the concerned circle, my lord. My lord, I need some instruction from the petitioner, my lord. This is a case of 2018. And regarding madrasa institutions, my lord,
And my lordship is well aware, my lord, now this has been converted into schools and amalgamation is also there. Now, what is the current position of both the institutions, my lord, is required updated instruction. my lord. Our case, my lord, is that they do not have the land, requisite land, and in our land, my lord, their school was functioning. And my lord, by taking advantage of that position, my lord, they had shown our land as their land and the provincialization benefit has been given. my lord. Now in this affidavit, my lord, certain document has been annexed, my lord. So I need to verify, my lord. A week's time may kindly be given, my lord.
Your madrasa is different from the.
Yes, yes, my lord. My lord, there are two institutions. One is my institution is, my lord, senior madrasa, and the private institution, my lord, which had been provincialized is a pre-senior madrasa. Our case was that, my lord, they do not have the requisite land. And in our land, my lord, just as a, my lord, temporary arrangement, they were allowed to function from our land, my lord, but by taking advantage of that, my lord, our land has been shown to be their land. And the provincialization has been given to them, although we have raised several complaints before the authorities, my lord, those were not given any heed, my lord. And subsequently, provincialization has also been given effect. Then this writ petition has been filed, my lord, and after a gap of 5 years, my lord, this affidavit has come today only, my lord.
Both sides are really represented. Mr. A.R. Bhuyan, and counsel for the petitioner, has submitted that he has received a copy of affidavit in opposition filed by the
Circle officer,
Circle
respondent
officer.
number 5.
within bracket respondent number 5 today. So we said affidavit is not on record.
And the
We said-
inspector of school, my lord, inspector of school has filed the affidavit in opposition.
Inspector of schools.
Yes, my lord.
Okay,
My
make it
my respondent number 5.
Inspector of
Yes,
schools
yes.
within bracket respondent number 5. The Learned Council for the petitioner sits. Prays for an granted time to obtain instructions. Next, in view of the nature of dispute raised in this petition, the competent authority of the Secondary Education Department shall also file their affidavit to bring on record the documents based on which the Kathalkur, Kathalkur, Anchalik Pre-Senior Madrasa was provincialized.
My lord.
And of the God, and the alternative, the Secondary Education Department shall produce the relevant records. Next, the Learned Standing Council for the Secondary Education, Mr. U. Sharma, and his Standing Council for the Secondary Education Department shall send a downloaded copy of this order to the authorities of the Secondary Education Department to bring this to their notice. Your name?
S.A. Borbuya on behalf of AW Oman, respondent number 8 to 16.
S.A. Barbia for respondent number 8 to 16 are present. You filed your affidavit, no?
No, Lordship, 4 weeks time will be granted to file the
Yes,
affidavit.
If the affidavit in opposition is not filed 2 weeks prior to the next date of listing by any of the respondents, except for respondent number 5. You show me the affidavit of respondent number 5. Where is that? What is that?
Circle of
It is only for respondent number 5 or for other respondents also?
So, my lord, I am representing the secondary education, including respondent number 5, my lord,
So
circle officer.
all of them will rely on this affidavit.
Not the provincialization order by the director of secondary.
No, just a moment.
And it is the inspector of school who has filed.
My lord, actually, government is required to file affidavit, circle officer is required to file affidavit because of
No,
land
no.
dispute is there, my lord.
No, we are not concerned with the land dispute. That will tackle.
Yes, my lord.
And for secondary education department, every authority of the secondary education department is relying on this affidavit, or they are filing separate affidavit.
Separate affidavit, my lord.
You file separate
Yes,
affidavits,
yes.
okay. Oh, okay, except for respondent number 5, all the respondents are put to notice that if no affidavit is filed on their behalf, at least 2 days prior to the next date of listing, the court would invoke the doctrine of non-traverse and presume that the statements made in the writ petition are accepted by all the respondents. And matter will be heard accordingly. Full stop. List on 22/5/2023. The registry shall take the affidavit of respondent 5 on record.
Obliged.
Reply if any by then.
Yes, yes, yes.
Okay, reply if any by the petitioner by then.
Yes, yes. Obliged.
12.
item 12.
May I please, my lord? My
Item
lord, the
number
order
12.
dated 5/4/23, my lord. They were given
Or
chance.
Lordship's
but
last
no
order,
affidavit, my lord,
if
come
we
out.
did not file an affidavit, my lord, 2 days prior, the doctrine of non-traverse suit, my lord.
Yes. My lord,
Yesterday
this
evening also I have received a,
petitioner, my
instruction.
lord, was appointed. my
we will
lord,
require some more
officially.
time to trace out the
Page
records as to
4, my
why
lord,
the
lecture 3
post
by
was
order
not
dated
retained by the
30 of
then
June, my lord,
Just a moment. Mr. Mazumdar is making some submission. Yes, please repeat again.
my instructions are, we would require some more time to get the information why the post was not retained by the then DEO at Darong. Otherwise, Lordship's order is clear, my lord. Lordships had said that the doctrine of non-traverse would be.
Because 2018, if the respondents don't take any initiative,
There was a little misunderstanding because the matter related to the BTC. BTC was involved, my lord. The department perhaps was on the line that it will be defended by the BTC. Now, the affidavit of the BTC, when we placed it before the department, that this is the position, they say it is not within their jurisdiction. Now, my lord, the matter has been taken up again after the last order. So there is a little difficulty, my lord.
My lord, page 18.
but you
my
see,
lord.
Mr. Mazumdar, everything is okay, but we'll have to proceed with the hearing. What can be done?
Because instructions also say that it was his appointment is not being disputed by the department. The thing is that his post was not retained. Now, from the instruction, from the repetition matter, the copy that was with me in the, I saw that he was appointed under a plan post. Now, if it's a plan post, my lord, the plan post are those where it is for a limited period of time. We are trying to find out under which plan he was appointed, and if that with the plan did his services
Oh,
end.
you have a copy of the repetition, you
No,
come
my
to.
lord,
the-
I had a.
You
copy of
take
the
the-
WhatsApp, it's difficult.
Just a moment.
Yes, madam, I've got a.
Just-
18, my lord.
Just a moment.
Yes. Page 18. My lord,
Just a moment. Come to page 26.
Yes,
my lord.
Questions of letter numbers, rather than the question of finance, the post created by OBB plan and brought under non-plan.
After training, my.
Then come to page 30. Mr. Chauhan, the second time, third time I'm repeating. Now I refuse to hear it. I'll adjourn it. I'm asking you time and again to stop. I'm showing him something, but you are insisting on a hearing. The list after 2 weeks to enable Mr. R. Mazumdar, Learned Counsel for the Secondary Education Department to get to get appropriate instructions and to file the affidavit. This matter. I've started the hearing. I'm asking him some questions, and then you are again interrupting. This is something I'll not like. You heard me. I was refusing time to Mr. Mazumdar. I'm asking him questions, and then again you are interpreting. Something I don't like. And this is something I'll not encourage. It's a court query which will have the privacy. Privacy will be the court question. I'm asking a question to Mr. Mazumdar. You have no business to interrupt that question.
Very much.
No, it's-
Item 13.
Hey, please, Lordship.
Yes,
In this case, Lordship, the respondent number 2 has filed an affidavit, Lordship.
yes.
In their affidavit, they have stated that though I was declared eligible in terms of Form B, Lordship, but due to declaration of ultravirus, due to declare ultravirus of 2011 Act, and they would not consider my provincialization, Lordship. To that effect, Lordship, I will examine, Lordship, the review order. One review order was passed by the division bench, Lordship. Whether that review order will protect my case or not, I will examine, Lordship. Moreover, Lordship, whether I am entitled to the provincialization, whether I am eligible for provincialization as per.
There's a judgment of this court which was placed before me.
Lordship.
It says that once the act has been declared ultra-virus,
Lordship.
it's the appointment would be now governed by the new Act 2017 Act. But if you say that there's a review order, I'm not aware of it.
Lordship, Lordship.
So I'll give you time then.
Lordship.
Both sides are duly represented. Mr. S. Talukdar, Learned Counsel for the petitioner, submit that he has received a copy of the affidavit in opposition filed by respondent number 2. And in the regard to he requires some instructions. Mr. According to matter stands adjourned today. List after, how much time, Mr. Talukdar?
Next week, maybe.
List after 2 weeks. Okay.
Obligation. Obligation.
Item 14.
Yes, you got instructions.
My lord, it was recommended by the SLC, my lord,
He was recommended.
my lord. Recommended by the SLC, the final is dated 4/1/2021. And flag mark it.
So we'll but then since Dr. Goswami is in court, I think he has not been communicated. Otherwise, Dr. Goswami would not be here.
Yes, fine.
The orders passed, were perhaps not communicated. Otherwise, there's no reason for Dr. Goswami to be here.
To that effect, I do not have the instruction, my lord, only that his name was recommended by the SLC. To that effect.
Okay, I'll record it, but I'll keep it pending. Otherwise,
My lord, my
we'll be in difficulty if
My lord, my lord, my
not been. Her Dr. P.K. Goswami. Learned
Probably
Counsel.
he is already appointed, my lord, because from all those.
No, it's,
21
I don't dispute what you're saying that,
My lord,
but knowing Dr. Goswami, I don't
My
think
lord, my
he'll
lord.
be here in court.
my lord, my lord.
He's a man of letters and words. He will not be here.
My lord.
Dr. P.K. Goswami, Learned Counsel for the petitioner. Next, upon instructions. On written instructions received by Mr. G. Pegula, government advocate, it is submitted that the candidature of the petitioner was recommended by the DLC in its meeting held on 29/7/2017. And his candidature was then placed before the SLC held on 4/1/2021. And that the SLC had recommended the petitioner for appointment in a grade 4 post under the office of Inspector of Schools, Dhemaji. Next paragraph. The learned counsel for the petitioner submits that he has no instructions in the matter. Next paragraph, be that as it may. Having regard to the fact that as per instructions to the learned government advocate, that the SLC has also recommended the appointment of the petitioner in grade 4 post in the office of Inspector of Schools, Dhemaji. It would be appropriate to permit the petitioner to take follow-up steps. Matter stands adjourned today. List after 4 weeks. Just add word there. Follow up by producing a certified copy of this order to the competent authorities. So this order can help you. The instructions produced or returned.
Item 15.
May I please, Your Lordship?
Yes, Mr. Das.
Lordship, was pleased to dispose of two similar petitions. Also, I am praying for a similar order with my learned friend Agnes.
But you'll have to produce instructions, Mr. Mazumdar,
Yes.
as to whether the appointments of the petitioners were acceptable appointment. That is the last query of the court.
Yes, madam. It was last one, madam. I have tried to trace out whether they had been accommodated as teachers or tutors, as was done with the screening process, madam. Their names are nowhere in the teacher or tutor list. That thing and
The
another-
order you are trying to show me, Mr. Das. No, the prayer itself is that his case should be placed before the screening committee.
Screening committee, yes. So it was placed before the screening committee, and it is the stand of the petitioners that the screening committee has not recommended them. If Lordship
Is it-
has that order, Lordship was referring to, madam, that's 2018 order. Lordship will find that the petitioners were appointed as assistant teachers in different ME schools in the Nagaon district were subjected to a screening process undertaken by the authorities in the education. It is stated that in the screening process, except for one candidate, authorities had not recommended others, including petitioners, for regularization. That was his initial case. madam.
The case Lordship which Your Lordship has disposed of exactly similar was Nagaon.
No, but regularization is- Financial very good.
No, this will be a factually different case. Because-
Hearing also that their services were regularized. Also regularized.
Mr. Das, you see, in this order which you have produced,
Same case.
no, it's not same. There's material difference. Because
These persons were also regularized in the year 1999. In case 5 also, I have given the details of. In case 5, I have made a chart.
are you in receipt of the notice? You're not in receipt of notice. So therefore, in the earlier case, there was a challenge because the individual show cause notices were issued.
No, in those cases also, individual notices were not issued.
No, I don't know, I'm reading paragraph 3. It says thereafter by the impugn order, the so-and-so department had directed the director of education to issue individual notices. Why their appointment should not be deemed to be illegal, irregular, and should not be removed from service. So that is what was the challenge.
No, that was a common order. That order is, it is annexed in this repetition also. Your lordship, 2010. The same order has been put to challenge here also.
No, but here your case is that your names were not recommended by the selection committee, the expert screening committee.
Then, one on seven also, page imping order also. In the earlier petition also the same order was challenged. Page 117 of the writ petition. Page 117.
So you are ready to subject yourself to the show cause notice. Mr. Mazumdar, then you can dispose it off. On the same ground, if he is ready to subject himself to that.
Then he'll be pressing only that prayer, madam. The other prayers, when there are other prayers regarding release of his salary, that will not be taken into account because the if we show cause notice, if his appointment is found to be illegal in that sense,
Correct.
that will
That
be taken up. Nazira Begum Pascal involved.
What you call the decision taken will prevail over all other what you call orders. Where is the chart of your appointment?
Chart of the appointment, yes, page 5 also.
Page 5 of the repetition.
Page 5 of the writ petition. Only first, that particular paragraph will be changed, otherwise it's same.
Page 5 chart.
But the only thing, my lord, this date of provincialization that they have shown the chart, that provincialization they never got. There is a statement at paragraph 2. At paragraph 2 at page 4.
No, they say it was para two says it provincialized on 1911.
During the time of provincialization, their respective schools, their posts were
It
dropped. So they were not included in the provincialization process. So this chart shows me the date of provincialization that they could not enjoy. Madam. Any regularization is
Okay.
at a later date. And that is why, my lord, we have to find out whether that regularization on appointments made by the school, my lord, whether they were appointments which could be regularized. That is why the earlier order.
Yes, because in the earlier order also, we did not write about the provincialization.
Yes.
It is only the regularization.
My lord, yes.
You have referred to.
They could be regularized if it was an irregular appointment.
I get
The
it.
appointment is by the managing committee, not by us.
I get it.
Could we have regularized this issue?
In this, don't write column 1, 2, 3, 4, 5. Column 5, date of provincialization is not to be given. Then rest will be same, I think.
Next, we will say the same chart also page 5 also.
Hmm?
Next petition also page 5 also, the chart.
No, there are no other changes required in this order.
No other sense.
Okay. Same. Same set of lawyers, Mr. S.K. Das for the petitioner, Mr. Mazumdar for the elementary education. And here there are 5 petitioners. In the last order, last paragraph 15, it says 6 petitioners, it will be 5. Only 2 alterations.
Okay, only the paragraph 2 will be set.
Okay.
Other will remain.
Okay, I'm too jittery about similar orders. Unless I check it,
Yes.
because it will otherwise multiply the petitions. Here, same 5. Same corrections. Okay.
In Deepak Kumar Saikia, the petitioner number 3,
Yeah.
she has already been accommodated as a tutor. So her
Okay.
regularization, that part would
So
not be
the-
necessary. We are not issuing Stokos notice to her because she has been accommodated as a tutor. We are not questioning
Okay.
her now.
In the next case, 8294, item number 16. Huh? You just add. In para 9, instead of 10, it will be 5 respectively. Huh? And then in para 9, you add. In respect to item 16, you add. In this connection, the learned standing counsel for the elementary education department, upon instructions, I submitted that the petitioner number 3, namely Kusum Bora, has already been adjusted as tutor after the screening process. And accordingly, he has instructions that the show cause notice would not be issued to the respondent number 3. Accordingly, the respondent authorities are exempted from issuing show cause notice to Kusum Bora, respondent number 3, and she would not be subjected to the re-screening process. Okay. This was
Bless you.
Yes, item 17.
All right. That is the last.
Yes,
My
Mr.
lord, in
Uddin.
this case, last time I kindly see the impugn order, page 23, my lord, last exercise.
Just a moment.
Lordship,
Just a moment. Just 2 minutes. What is the date of your superannuation?
My lord, now my age is 59 years, 3 months, 4 days. So, my lord, in the month of July, I think, my lord, will be the first conversion.
The correction of age will give you advantage of how many years of extra service?
My lord, his date of birth is, my lord, incorrect is 1964 and corrected is 1968.
4 years.
4 years.
Yes.
My lord, the board of directors, my lord, Seva, corrected my date of birth, my lord. And accordingly, I have submitted application, my lord, before the director of higher education, my lord. And the director of higher education, my lord, rejected my prayer on the ground that I have not submitted the same within 2 years of passing of the examination of matriculation, my lord. My lord, seems to be a cryptic order, my lord. Lordship may kindly see page 14, page 23, annex of 14, man.
Page?
Page 23, my lord. My lord, Seva has already filed the affidavit in opposition. They have stated that I have submitted application and accordingly they corrected it. But they did not, my lord, restrict or any question about the delay of 2 years or 3 years, my lord. But the director of higher education, my lord, this point.
Where is the proof of your, what proof you are relying on the date of birth?
Lordship may kindly see. Page 12, my lord, is the correction order issued by the Board of Secondary Education. My lord.
It is based on what?
It's based on my application, Lordship. Lordship may kindly see the application. Page 9 is the first application in the year, my lord, 1999. Through proper channel, my lord. So,
what is the proof given? No proof is given.
admit and mark sheet, my lord. All original, my lord. And Lordship may kindly see page 10, another application, my lord. Lordship may peruse page 11, my lord. This is office order, my
No,
lord.
no, I'm just asking you, Mr. Uddin,
Yes.
this application is based on what document? What is the proof you are referring to
Yes.
when you say that my date of birth should change?
Lordship may kindly page 13, man.
Page 13.
Page 13, 14, 15.
There's some corrections. Who made these corrections?
Is Seva, my lord.
You are a candidate of the examinations was 23/11/84.
84 years, my lord.
You made
Right.
these corrections through Seva on 22/5/2015.
No, my lord, Seva, yes, my lord.
Correct.
26. Yes, my lord.
Now, let me ask you a question. Today, somebody files an application that, no, please treat my date of birth. Let me take an example of date of 1/1, say 15, somebody is born.
Right.
He gives an application, no, please treat my date of birth as 1/1/20.
Lordship may kindly
Is it-
peruse the affidavit filed by the.
No.
This
I'm
court
asking you
is
the
specially
question.
direct, lordship.
If somebody makes an application, is it permissible to change the date of birth?
Lordship is permissible. Lord. Lordship may kindly see fundamental rules and subsidiary rules. My lord, subsidiary rule 8C.
FRSR. FRSR. Like fundamental rules. Yes.
In my book, page 29, my lord.
No, rule number
SR 8,
SR 8.
8C. Relevant 8C, I think, my lord.
Commissioner and head of the department may alter the recorded.
Yes, ma'am. The comment question also relevant, madam. Comments.
Yes.
May I read, madam?
Yes.
The provision of SR 8C contemplate that if there is any dispute regarding the date of birth recorded in the service book and there is some prima facie evidence, the competent authority should hold an inquiry in the matter for a decision, and in such an inquiry, the principle of natural justice should be followed, held by so and so so and so. But if on such inquiry it is found that date of birth recorded in the service book is not correct, and the later date of birth is as alleged by the employee is correct, the retirement of such employee on superannuation on the basis of date of birth recorded in the service book would certainly amount to punishment as laid down by the Supreme Court in so and so so.
No,
No.
so then you see, my question is that the prayer, I have given an example, 1/1/15, somebody is born. He files an application, please treat me as born on 1/1/2020. This is a simple application. In your case also, it is application like that. It is not supported by any document to show that you were born on a date anterior to what you claim. So supposing if in one case, 1/1/15, somebody comes and says, treat me as 1/1/2020. Should that be allowed?
But as per school record, madam, as stated in the affidavit of the SEVA and as forwarded by the letter application which was submitted,
as per my lord, school records.
Where is that record?
Lordship may kindly see the affidavit filed by.
No, no, no. Please show me the record. If you are saying that there is a record of school, please show us that record.
Lordship, that record has to be called.
Mr. Udin,
Yes, ma'am.
you see, what is a certificate?
Like birth certificate, my lord, etc.
No, birth certificate is an original certificate.
Lordship.
But what does a certificate or the school's certificate given by the authorities mean? If a headmaster gives a certificate to the effect that as per the school records,
Lordship.
somebody is born on 1/1/15, that is only a secondary evidence. It is not a primary evidence. A certificate itself cannot be substituted as a proof.
Lordship.
Correct.
So, my lord, as I understood, my lord, for this detailed inquiry is required as per my.
No,
lord,
you are the petitioner. You will have to produce a copy of that extract. Original school record. You produce the extract of the school record.
my lord.
Don't give us a type copy. Give us the original photocopy of the extract.
Yes, ma'am.
Then we'll
That
make an
is school
inquiry.
record- School record, my lord.
Then we'll make an inquiry. If you can primarily satisfy the court. Yeah, otherwise, it will be a fishing and rowing inquiry
Lordship.
to find out what your age is. Why should the court take an individual and find out from the documents? We produce that school record.
Well, SEBA has submitted it MRS, it is called MRS. Lordship, may kindly produce the.
No, you see, that is something they have done on their record, but it is sacrosanct for the court.
So, my lord, Lordship may give some time, I will produce that
Yes,
record.
they may be right, they may be wrong. We don't know.
Lordship, that is correct. my lord.
But when the authorities are refusing to do it,
Only, my lord, my hurry is that this petition is going to dead, my lord. So,
you get it. We'll fix whenever you want. When do you want the matter to be taken up? We'll take it on that day. You choose a date.
my lord. Lordship, will fix it next week. Anyway.
There's a calendar in front of you. Just tell me a date. I'll fix it then. Avoid Tuesdays and Thursdays.
Lordship.
Fix any other day. We'll take it up on that day.
Lordship, may fix it on 9th, my lord.
9th.
Yes. sir.
No, 9th is, I have told you to avoid Tuesday and Thursday.
Lordship, or 10th, Lordship.
10th, okay. Raise this matter on 10, or both sides are represented. Raise this matter on 10/5/2023 to enable the land council with the petitioner to produce a photocopy of the school record showing the date of birth. Full stop. List on 10/5/2023. Actually, I just noticed officer sitting behind. She's on personal appearance.
Most of them.
The officer is in personal appearance. We'll take it up then. We don't want them to sit here. Which item?
Item 32.
32 is the council present for the petitioner. Who's for the petitioner? You are for the petitioner in item 32.
Lordship?
You are there for item 32.
Yes, Lordship.
Okay.
Yes, that will be.
I'm
seen-
sorry, it is item 31, madam. My mistake. Item 31.
31.
Oh,
31, madam.
31.
Mr. M. Datta.
M. Datta.
I'm for 32, Lordship.
No, it's okay. Since the officer is there, I'll take it up.
Madam.
Just give a scroll for Mr. M. Datta. For petitioner. No, but the concept of the here.
So perhaps the AG, the AG will appear in the matter rather than.
Okay.
Otherwise, my lord, in this case, my lord, the non-compliance. Shortly put, my lord, we had moved a writ appeal which was dismissed, and we have filed an SLP, my lord, as of date. We are not. It was the appeal was dismissed around a month ago, and the SLP has been filed. We have got the numbers also, the filing number and all.
Okay, but I can't pass orders in the
But,
absence.
if it's taken up
In-
immediately after lunch, my lord, I'll have both Mr. Datta and the DG.
In case of the personal appearance, please make a prayer for upgrading it.
I'll do that.
Okay, we don't want the officers to be here. for the entire day. Ah, 18,
Item 18. Timing losses, as class is paying this case.
Timing.
One loss.
okay,
According to whom?
timing.
Double.
19,
Item 19.
My lord, may I please as your lordship? Not in this.
you got the status on record, Mr. Mazumdar?
My lord.
You are appealing the matter.
19.
You are required to bring on record the status of the present petitioners.
Yes, item 19. Item 19, we have the instructions, my lord. I'll have to file an affidavit on this. Some have been accommodated, some are, my lord,
No, that you have made a statement on the last occasion on 12/4, we have recorded that.
yes, my lord.
You are required to bring on record
Yes.
the status of the present petitioners.
Well, out of the petitioners, few have been accommodated. And when I made the statement, my lord, we had a screening list. I did not know who was accommodated, but here, my lord, around 7 to 10 have been accommodated. That matter I bring on, she will have it Friday, even Friday, my lord, I can have it on record. ইহঁতৰ ভিতৰত।
Friday, you will get a walkover for the reasons you know. Friday, you will get a walkover.
Friday.
Ah. You have to follow the old, what you call, old proverb of speaking to the wall. Wall have ears. They'll hear you and tell you tomorrow. So Monday,
Monday, my lord, 8th, my lord, we'll have the.
Okay.
My lord, yeah.
both sides are represented. On the prayer made by Mr. R. Mazumdar and council for the second elementary education department, the matter stands adjourned to enable him to bring on record the status of the present petitioners. Except the list on 8, list on 6. Okay. Yes, item 21. Yes,
Item
Mr. Ahmed.
21, my lord, petitioners number, sorry,
same thing, last case,
my lord, item 21,
same.
petitioner number 1, petitioner number 3, 4, and 5, they have been accommodated. For the others, my lord, I'll file a affidavit in opposition.
Okay, no, not required. If you have that instructions, we'll record that.
One,
Just a moment. Mr. H.R. Ahmed, land counsel for the petitioner is present. Pursuant to order dated 12/4/2023. Mr. R. Mazumdar, and its standing counsel for the elementary education department has submitted that the petitioner number 1,
3,
3,
4,
4,
and 5.
and 5 have been accommodated as tutors.
Yes, my lord.
In the concerned schools, and they have accepted the appointment
Yes.
and joined. Accordingly, it appears that the issue raised in this writ petition would be live for the petitioner numbers 2
And 6.
and 6. Next paragraph. The learned counsel for the petitioner is given time to obtain instructions Full stop. Next para be that as it may. In view of the nature of prayer made in this writ petition. An attempt will be made to hear the matter on merit. In respect of petitioner numbers 2 and 6. Unless contrary statement is made in respect of respondent numbers 1, 3, 4 and 5. Next for a list on 24/5/2023. We'll hear the matter if you don't have instructions for 2 and 6 only.
Item 22, I'll seek some time. There are too many repetitions, my lord. I could not verify. I need a copy of the repetition also, my lord.
Okay, give a copy to him.
Monday, Monday.
Monday, same item as item number, that was
19.
19.
same as.
Publish me.
Please give him a copy of the petition.
My lord.
My lord, in item number 23, I have received the instructions, my lord, but they are not adequate. The petitioner appears to have been placed under suspension and there was some sub judice in the matter, my lord. Perhaps 10 days time, my lord, I can.
He's challenging the promotion of respondent number 5.
5, my lord, yes. But the petitioner himself was under suspension.
But
Is what I'm
his own
told.
conduct is not being questioned by him.
No, but in the issue would be whether when he was placed under suspension, what happened to later on and whether he was entitled to have been considered and whether he was considered or not. That is what I find out.
No, because for that we already have a decision of this court as well as Supreme Court that once
that
he's
he-
once he's suspended or something, then you have to follow seal cover procedure.
Yes, my lord. Now, that is what I have to find out, my lord. How come he was not? This came on recently only. To find out. And he was also adjusted from the non-formal education.
No, all that is okay, but I'm only interested in the, you see, why I'm so anxious is that he's making a prayer in 2019. We are in 23.
In between 2 years, my lord, we also did not participate much, my lord, in this COVID period.
No,
There
that
was
is
not
okay.
much communication.
That is
between
okay,
us.
but the officers will have to do that exercise.
Lordship will give me 10 days time, my lord. I will have the affidavit filed. Because here I do not have to probe much into it, my lord. I just have to have a few records. I can say what is the situation.
Only that whether his case was considered
Yes.
in the seal cover procedure or not. That is the only issue. Both sides are duly represented. On the prayer made by Mr. R. Mazumdar, learned counsel for the Elementary Education Department, representing respondent numbers 1, 2, 3 and 4. Further 2 weeks time is granted to file affidavit in opposition in the matter. Next para, in the alternative, it is provided that in view of the nature of prayer made in this writ petition, whereby the petitioner is seeking quashment of quashing of the order of promoting respondent number 5. Comma. It is provided that if affidavit in opposition is not filed within the time allowed, comma, the elementary education department shall produce the relevant records relating to the seniority position of the petitioner and respondent number 5. Comma. The exercise for considering promotion of respondent number 5 by holding DPC and records to show if the case of the petitioner was considered in a sealed cover procedure. Next paragraph, the learned standing counsel for the elementary division department shall send a downloaded copy of this order to their respondent authorities for doing the needful. Respond, give a date after 2 weeks.
19.5.
So I've given you an alternative.
Yes, I'll produce the records.
If affidavit is not filed, then records relating to 3 aspects.
Yes.
I don't know how it is contained.
It comes from the district level, so. The
Thomas,
proposals come from the district level.
No,
We
you
just
see,
have-
I just wanted clarity in the order.
Yes,
Number 1, I would require the records relating to the petitioner and seniority position of petitioner and the respondent number 5. That is 1. Second is records of DPC. And third is whether the case of the petitioner was covered, was considered in a sealed cover procedure. So
3 things are.
there should be clarity in the order, otherwise, that's why I'm asking you.
These 3 things will clarify.
Okay.
Madam, the personal appearance matter, madam.
Yes.
Petitioner's counsel is here and Mr. Khatunier will appear, madam. Fix up, you can.
At 2 o'clock, we'll take it up. Which I have to rise.
Eight five. 8.5.
এই বাইদেউ জনী যদি আহে এই যে শাৰী পিন্ধি যে বাইদেউ শাৰী পিন্ধি বাইদেউ যে গৈ নাথাকে অফিচাৰ বাইদেউ আহিলে ছয়মাহ নকলে এইবিলাকৰ কাৰণে প্ৰিন্সিপালৰ মানুহ থাকে। বাইদেউ বাইদেউ বহুত ডাঙৰ আজি বাইদেউ হ'বও পাৰে ইয়াত চাব লাগিব। দেই এখন mistake হৈছে এতিয়া মানে ইয়াত যিজন মানুহ বহে তেওঁ আজি আহা নাইতো, তেওঁ সেই লিষ্টখন মানে কৰবাত থৈ দিছে। কাইলৈ তেখেত আহিব, মই চাইছো পোৱা নাই লিষ্টখন। তেওঁ লিষ্টখনত চাই পেলাই আপোনাক ফটকে কব লিষ্টখন ঠিক আছে। আপুনি ডাঙৰ কালিহে আহিব, মই লিষ্টখন পোৱা নাই হা। তেখেতে কাইলৈ আহিলে আপোনাক তেখেতে কৈ দিব দেই। হৈছে আকৌ আহিব নহয় দুটা। নহয় সেইবিলাক যে বহুত বিৰক্তি আজি তেনেকে যদি ময়ো আপোনাৰ ময়ো আহিব বেয়া পাওঁ। কিন্তু মানে কথাটো হয় কি এতিয়া আজি আপুনি যে নাই মেনচনতে ছাৰে মোক কৈছে মই ফেনখন অফ কৰিব দিলো, এইফালৰ পৰা কি আইটেম ছাৰে কি অৰ্ডাৰ দিছে সেইটো শুনা নাপালো। যদি মেনচন হৈছে ডেট দিছে সেইটো আইটেম যদি উঠিলে আহি পেলাই তো ক'ব পাৰে মেনচন হৈ গ'ল ছাৰে ডেট দিলে আপুনি এখন কি হৈ মাতি আছে। এই বহুত ডাঙৰ কথা ন, সেইকাৰণে মানে আপুনি সেইটো কেছটো আমি কৰি থাকো ন। মই নিজে পেণ্ডিঙত কৰি আহিম বুলি কওঁ। মই যে থাকিয়ে চাৰ্ভাৰটা বনাই মই ছেকেণ্ডমেণ্ট নিবিচাৰো, কিন্তু এইবিলাক দিগদাৰ যে ডিৰেক্টৰ চেৰেক্টৰ আহি বহি আছে, ভুল হলে আমাৰে লাজৰ কথা হয়। হেল্ল' হয় হয় আচ্ছা আচ্ছা মই এই এটা বস্তু এটা কি
And therefore this repetition fails and the same is dismissed. It is also mentioned in this order that by previous order dated 27/4/2023, the court has issued a notice to the concerned authorities to show cause, and it has been directed that a separate interlocutory application be registered for the same, which should proceed notwithstanding the disposal of this petition. Notice issued by order dated 27/4/2023 is made returnable on 30/6/2023. That notice issued on that date is made returnable on 30/6/2023. Therefore, it is reiterated that the registry shall register the appropriate suo motu interlocutory application and on this case in connection with this disposal of writ petition. Writ petition is disposed of. With dismissal. Yes, 31 personal appearance.
Item 31.
Yes,
Director is present, my lord.
yes. What do you have to say?
In fact, madam, pursuant to the order of the honorable divisions, madam, we have prepared an SLP, madam. And it is already been filed, madam. So I'm praying for some more time for compliance, madam.
Yes, Mr. Dutta. If that be the case, we adjourn the matter for some time.
We have not received copy. We file a caveat mail there, in the Supreme Court also. We file a caveat.
It's okay.
In fact, madam, we have today I got the diary number. Yesterday it was filed, madam. Today I got the diary number, madam, in honorable Supreme Court, madam.
Okay. So for the time being, we are exempting the personal appearance of the director.
And in respect number 3, madam, she is unwell, madam. That's why.
Mr. M. Dattal and counsel for the petitioners. Pursuant to order dated 4/4/2023. Dr. Suranjana Senapati, the Director of Elementary Education Assam, is personally present, along with Mr. N.J. Khatunia, our learned counsel. The learned counsel for respondent number 4 has submitted that the respondent number 3, Dr. Vijaya Chaudhary, the Secretary, Elementary Education Department, is unwell and prays for exemption of her personal appearance. In view of the submission made, the personal appearance of the respondent 3 is exempted for the day. Next para. The learned counsel for respondent number 4 has submitted that against the order dated 3/3/2017 passed by this court in WPC 268 of 2003, in respect of which this present contempt petition has been filed, was assailed in WA 355 of 2022. No, something is wrong. The 268 is 3/3/2017. Order dated 3/3/2017 passed in WPC 268 of 2013. Was assailed in WA 355 of 2022, which has been dismissed by order dated 20/2/2023. First off, it is submitted that the state has preferred an SLP against the said orders. Which is now registered under a particular diary number issued by the Registry of the Supreme Court of India. First off, it is submitted that the matter be adjourned to enable the respondents to comply with the order of this court, subject to whatever orders that are passed in the SLP filed by the respondents. Full stop. Although near filing of the SLP before the Supreme Court of India would not be a good ground to postpone the proceedings of this contempt petition. So nonetheless, having regard to the fact that SLP has been filed by the respondents and the by the state respondents, by the state. In the education within bracket elementary bracket course department. The court is inclined to adjourn this matter for 4 weeks. Full stop. List again on. Just before that, you write. It is made clear that if the proceedings carried out against the judgment and order dated 3/3/2017, passed in WPC 268 of 2017, remains unfavorable to the elementary education department, we go to proceed further in this matter on the next date. Next para, till further orders the personal appearance of the respondent numbers 1, 3, and 4 is dispensed with. List on, after 4 weeks, give a date.
5th of June. 5th of June.
Obliged, Lordship.
This bail hearing matters fixed. Okay, 24 is one matter. Okay. I'll take up item 24 first. I'll take up 24 first, then I'll take up the bail matters.
Item 24.
My lord, in this case, records were called for, my lord. We have received the report today morning only, my lord. My lord, let the matter come up in any other day, my lord.
Just a moment.
Higher education was to file an affidavit, madam.
Just show me that file for a moment.
My lord, that file has been received by K. Gogoi, my lord. At his house.
We will take it up next week then.
Yes, yes, my lord.
Both sides are duly represented. Mr. S. Das, learned counsel appearing for the higher education department, submits that the records have been received by Mr. K. Gogoi, standing counsel. They faced some time to peruse the same and to produce the same before the court. matter since adjourned today, list on. Next week, give a date.
Secretary.
12th of May.
That's right.
Yes, you've gone through this scan copy.
My lord, some.
Item
Please use,
25
my lord,
with 26.
Both from the same FIR.
Yes,
Third schedule also, my lord. My only limit, idea in lordship also gone through the records, my lord. But
25
I
items,
have
that is my
annexed idea, my lord, the charge sheet. Your lordship will find,
where is the previous order?
your lordship order is page 59, 60. In item number 25. School of Organization.
What is the stage of trial, Mr.
Not
Parashar?
yet, madam, even there, because Skunda is there, so even but
Trial not yet. my lord.
there is no chance of my lord there. But today is Mario your lordship will find.
How many
1
days?
year, 2 months, 10 days, so far 25 is item 25. Arrested on 22/2/22. 22,
27/7.
item 25. And item 26, my lord, arrested on 27/7/22. 279 days, that is 9 months, 6 days. Item 26.
How many days?
9 months to 6 days, 279 days. Item 26
26.
and item
But
20. My one
Mr.
request, my lord,
Chaudhary,
actually,
they-
they are
they-
not the main, my lord. Actually, from the, you'll also kindly see that from the charge sheet, the allegations, my lord. Page 50, you'll also kindly, page 50. Against them,
page 50.
50.
Just a
About
moment.
this petitioner, my lord. Page 50, my lord, middle portion that you'll also.
Just give it 2 minutes. Just give me 2 minutes. Page 50, yes.
Yeah. 20 years, man, actually, he was reading in that particular madrasa, I don't know, he was appointed. That man came, he wanted to some shelter. He does not know anything about his antecedent part.
Because what do you call, if you come to page 48,
Yes. Page 38,
48,
48, yes.
yes, this material evidence, there it gives what was found in your mobile.
My lord, 48.
Material evidence.
Material evidence. On 22/4, seized one mobile and did same as to accuse Saeed Ahmad. Right, my lord. The seized mobile was sent to so-and-so's expert, report was collected, and from the analysis report, it is found that screenshots of the book has sections in Jihadi and Mujahideen. That person, my lord, this person who was Hamidul, he was his classmate in that madrasa. He came from here, my lord, he wanted to, and he was teaching there, my lord. So that's why, my lord, he wanted SIM card that was given, my lord. This is the only thing, man. And I will refer to some of the judgment your lordship will see, my lord, as your lordship's my lord. That itself would not do, my lord, that here. Yes. So this one, so item 26 is concerned, my lord, page 49. Item 26 is concerned. Same thing will do, my lord. Page 49. About Abbas. Against him, my lord, against Imran Hussain took shelter at the house. That is that here. So one is sheltering, one is harboring, my lord. Now judgment, your lord, yeah, this is my lord, latest, my lord, appeal 1723. Your lordship will find. Criminal appeal number, it is not yet reported, my lord. Yadala Subbarao and another versus Union of India. Your lordship got it, my lord. disposed on 17 April 23. Paragraph 10, 18, and 21. This is what's called details matter, paragraph 10. Ten, 18, and 21.
There are 10 you said.
Yes, 10. 10. One of this. 10, then you'll kindly come to 18. Almost similar nature. 18. Here also shelter and logistic support. Page then 21. Indication of 43 D 43 D.
I'm just giving you this.
Yeah, page 21.
Mr. Das.
Uh,
Mr. Das.
No, we are having copy on UPA.
Evidence.
Voice.
SROB.
And then but page 21, my lord. Your worship will see, my lord. Just I am showing,
Yeah, I've seen that. I just asking this question since I have a benefit of a senior counsel here.
my lord.
Since I have a benefit of a senior counsel here, I am just putting that question. You see, please come to section 10.
Yes, ma'am.
Illustration B.
Yes.
In the next page, you will find illustration B.
Illustration B.
B or 2, whatever it is.
2, suppose
Huh.
2. Roman 2.
Huh.
This is the law, madam, but here a special act itself shows something, madam. UP is a separate act, madam, a special act. This is of course in the trial it will be requested, that will be there, madam.
No, not trial, because you see.
But now your lordship will see, madam, what this.
In
about
this,
act,
in this UAPA,
Yes,
what are what are the sections involved?
yes, but I come on the 19 according to me. This.
No,
kind-
no. No, you see,
Oh, registered, my lord,
120B is
Yes,
there.
yes, it is there, madam.
So conspiracy is there.
That section is there, man. But only question was whether I had knowledge or not. That of course is a matter of trial, I see, man, but
Because
I
you
I
see,
categorically stated, my lord. And none of the witnesses, just have a look to page 10 of my petition, man. Page 10 of the petition. But paragraph 8, my lord, it starts from page 9. Paragraph 8, petitioner stated that from the charge sheet as per the conclusion drawn by the investigating officer, the allegation against the present petitioner is totally different from then other co-accused. Main allegation of the petitioner as per the investigating officer is that he is liable under section 121A, regarding section 19 IPA Act for the harboring, so and so, so and so. Now your lordship, IO is in this regard, the investigating officer mainly relies on the statement of witnesses. These are the witnesses, my lord, Arfija, Amir, Imran Hussain, Abdul Hai, I have stated here, my lord. And your lordship will kindly see, my lord, that what she, if we just say, in her state, that will be available in the record also, my lord. In the charge sheet also it is there. Arfija did not say anything.
You have the IPC with you.
Yes. Yes.
Just see 121. There's an explanation. 121 capital A.
Capital A.
There's an explanation.
And they said it is not necessary that any act of illegal omission shall take place in persons thereof. That is not necessary.
So with all respect to this citation
To
you have given,
constitute a conspiracy. That is, I think. Under this section, it is not necessary that any act of illegal omission shall take place in persons thereof. But my case come on the shelter and I have, that is a specific matter. There are no witnesses. They have, my lord, actually based on the evidence of those persons, statement of those persons. They have not said anything about it. So prima facie, my lord, it is not like that of the 37 of the NDPS Act.
no, because in 120, you see, that's what I'm asking you a question.
Yes,
My
but
question,
that matters conspiracy, the section
my,
is there.
my,
my lord.
no, you see, my question,
Yes.
I'll just indicate the reason.
But charge sheet, no conspiracy, nothing, so how these persons are
No,
concerned.
not that. Just let me follow the question. I'll tell you.
Yes.
Uh,
Some other judgment also I will refer my.
if you come to page 48 once again,
48.
I'm now concentrating on this Syed Ahmed,
Yes, ma'am.
correct?
Syed Ahmed, yes.
Yes. Now, the third line, the CFSL report was collected from the, and from the analysis report, it is found that the screenshots
Yes.
of the book had sections on jihad and mujahid.
Yes.
Some riot videos were also found in the data. Voice recording information about the release of Imran and others by Sipahi Jala Court on so-and-so is also found. Also, the speaker in the voice recording, within bracket, Tutor Saeed, is a different man, stated that Imran stayed in his place just for a day in case of an apprehension. This indicates that the accused are radicalized and are engaged in radicalizing others.
Who is the accused one?
Huh?
That is matter that about Saeed.
That is about Saeed.
Syed Ahmed.
No, you see,
No.
that is why I'm posing you questions in this
Yes.
regard. You see, when it comes to the act of waging war on the country,
Yes.
then if I've understood section 10 correctly, then it is that an act independent of others can be a part of the conspiracy. That is one. Second is 121A, when it says that the independent act shall not be required to be proved. Then from this, what I understand is that bail is one part where the Supreme Court has dealt with it. But the question is that if the conspiracy, if at all, it is prima facie shown, then the independent act of some others who are waging war against the country, it will be covered by the definition of what you call conspiracy once. It gives the same sentence or sentence of 10 years, I think.
Yes.
Is it 10 years?
Uh,
It is 10 years, I think. Huh. So it gives us, it gives a maximum sentence of 10 years. Let us assume, I may be wrong.
Next 10 to 10 years.
So 10 years. So that comes in. Now you see, from the decision of that Satyendra Kumar until it requires that the minimum punishment sentence of half of the sentence should be gone. Then it then the accused are entitled to.
Also, it also provided. 436A, capital A.
436A also, yes.
Yes, it is there.
So then.
Your worship is putting that part in, and that my only question, my lord, that is now we am for bail only, man. I have come for bail.
No, for bail also.
So, by
You see,
emergency, my lord.
statement by a co-accused is not relevant when there are material evidence
Yes.
in form of the data of mobile showing that there is a conspiracy.
But that is
There
not
is
yet
a-
established, my lord. The trials
No,
only
that
it
is
will be there.
true.
Suppose
Here at bail,
in case but he comes out acquitted, my lord, then that is why
Because-
what is the concept, my lord, that it
because
is-
somewhere in this in the charge sheet,
Yeah.
I've read about two persons when X was arrested elsewhere, Y fled away to Bangladesh.
Oh, that
That
some
is,
other case at the Morija or it.
I don't know. I don't remember that much.
Maybe, my lord. one.
I just cursorily read it. I don't.
Huh? Yes.
So it's fled away. So you see, when the question is that for the consideration of bail, one of the considerations that he'll not fly away.
No, that is, my lord, he, no connection with Bangladesh is, my lord, here. He's permanent here, he's having shop in the market, this sofa item that is 25 is concerned. And 25 is concerned, so 25 is concerned. He's a permanent, he's having shop, he has nothing to do, my lord. Sofa 26, he's a cultivator, man. He's a cultivator. There is no question going, my lord, straight away, my lord. That your lordship, bail will be there in that here, my lord. So my only question, my lord, this poor, very poor people, these are not, maybe victim of circumstances, my lord. Sometimes people come, he came here and he engaged the imam. Now one imam is there, my lord, people go to the mosque to hear sermon, my lord. These innocent people, they do not have any interest, nothing at all, my lord. No point of time they are involved in this aspect. They do not know what is jihad even, my lord. When we interact these persons, my lord, like you say that they appears to, they do not know anything, my lord. But they are now. So that's why, my lord, my only prayer in your lordship. at
Yes,
this
Mr.
stage,
Parashar, what do you say?
Yes,
and another judgment just, my lord, your lordship.
Yes.
It is, my lord, 2000 criminal appeal number, my lord. I'm sorry, I'm having one. I'm giving the copy, my lord. Criminal appeal number 1302 of 21. Decided on 28 October 21. Party's name is Thawa Fasal, Union of India, paragraph 21. Just paragraph 20. Najib case also your lordship is remember. Here paragraph 22, 20. 21 TSCC. Photo.
This is reported.
Reporter, madam. May I know the status now?
I use Supreme today. It is reported in 2021 0 Supreme 650. 21
21,
0 Supreme
yes.
SC 650.
Zero Supreme.
Since I use that more often than SCC.
Anyway, we will find it, my lord.
uh,
Then Najib case, my lord, 21 3 SCC.
just a moment. If you are convenient with SCC online, it is 2021 SCC online 1000.
1000.
Okay, what is the next? This
the-
paragraph 20.
Yeah, oh, yeah, that's it, paragraph 21.
Yes.
Then 21 3 SCC, 713 and Najib case, my lord, just I'm giving my lord. Your lordship might have gone through that
I don't remember.
paragraph 19, man. Paragraph 19. Just a small paragraph one. This is regard to the NDPS matter, it is West Stinger West. Buster, this bus petition.
Okay.
The paragraph 5 of both the cases, just have a look, my lord, and your lordship will decide. Paragraph 5.
Paragraph 5.
What is the relation of those persons I have stated in both the cases? Paragraph 5. Page item 25, page 5, my lord. How he came into contact with that person, my lord. That paragraph 5.
Okay. Yes,
Malad,
Mr. Parashar.
Yes, from the record, Malad, I have also, though it is reflected in the Sasid also, Malad, Syed Ahmed has took shelter, Malad, Imran Hussain, Malad. Both their statement interrogation, Malad, by the IO, I have trademark, Malad. And from their, Malad, severe analysis, Malad, it's revealed that they are communication. And one thing is that they usually not using this normal sense of Malad, calling and Malad, send messaging, Malad. They have used Malad one screen app, Malad, named Omimo. That is explicitly used by that Al Qaeda and all other agencies, Malad. As per the Sasid, Malad. In
Which page?
page, in I think 26, Malad. Conclusion and investigation, Malad, page 49, Malad. 49, Malad. Conclusion and investigation, Malad. Second paragraph, Malad. Third paragraph, conclusion and investigation, Malad. Third line, they use the ridiculous men do not make normal mobile phone calls and normal messaging tools. They use Malad, secure communication channels using conversations app. As per the central agencies, such communication channel is exclusively used by Al Qaeda for communicating and this network calls, Malad. And in the top, Malad, there are CDR analysis is mentioned in the Malad, page 49 evidence, but during the analysis of CDR, Malad, Syed Ahmed and Malad Imran, Malad. And Imran, Malad, already took Malad, training, Malad, for this training. And one day he took shelter in the house of Syed Ahmed. In their statement also, Malad, it is reflected, Malad. And one person is still, Malad, absconding, and maybe there are some other person also, Malad, subsequently. And trial is, yes, trial is not yet started. And regarding the other person also, Malad, in the same Sasid.
That's could be UAP, unlawful activities. Prevention Act. Unlawful activities. You. Not P, you. Not P, you. You, unlawful activities. Just pass me a book, Unlawful Activities.
Oh, yes, yes. But page 50 my lord, a friend said about this Saeed Ahmad. So he was my lord, he is liable for the punitive action under section 121A, reduced section 9.
Three years to life,
Hello? Yes.
3 years to life,
Oh, that one 19.
19. Okay. Okay, I'll consider and pass on this.
All the paragraph 5 of both the cases.
Today I won't have time. I said, Mr. H.R.A. Chaudhary, Senior Counsel, assisted by Mr.
Ayu Chaudhary.
I.U. Chaudhary, Counsel for the petitioner, and Mr. K.K. Parashar, APP for the state, based on 8/5/2023 for delivery of orders. Because today I have some work, I won't be able to
8-5.
possibly 8/5 for delivery of orders.
Regarding Malad, item 26 is Abbas Ali Malad, in the Malad, page 50 Malad, regarding his involvement also Malad reflected in the Malad conclusion part.
Page 50.
Page 50 of the same petition Malad, last three lines of the Malad first paragraph Malad. Further, there are sufficient evidence of involvement of the band organization ABT, is Bangla Malad, of Abul Qasim, Hamid, and
You are reading where?
page 50. Item number Malad, 25 also Malad, in item 26 Malad, it may be page may be different Malad.
You give page item 25, page number
25 Malad, page
page
50.
50.
50
Okay.
Malad, last three lines of the first paragraph. Further, there are sufficient evidence
yes.
of involvement with the banner organization ABTs, Bangladesh Malad, Abul Qasim, Hamid Ali, and Abbas Ali. This ABT is a Malad relation with Malad, Al Qaeda Malad.
Abbas Ali item 26.
Yes, Abbasar is item 26.
So 1820, 21 and 1820 of EPF. But SCC should we take or it will remain SCC?
Pardon me?
SCC I have given my lord. It should remain or should I take?
No, you take back the book. Book I will return. Book I will return. I just not reading.
Obliged.
You'll get back your book. Only today I don't have time. Day after tomorrow I won't be able to visit. Both cases. Twenty-seven.
Item 27 with 28.
Yes, Mr. Sahu.
My lord, item number 28 can be taken up first, which is review petition. And 27 is the contempt petition. Contempt.
28 you want to take first.
28, item number
28 is review.
review.
Yes.
My lord, in this case, 500 metric tons of scrap, iron metal scrap, was disposed by the petitioner. So by it,
Just one.
Yes.
Yes.
My lord, in this case, 500 metric tons of scrap was to be disposed through e-tender. And e-tender was being the respondent was being the highest bidder. His tender was accepted with this condition that central excise will be 10% and VAT will be 5% and 1% is the TCS, tax collection resource for income tax purpose will be charged extra. Keeping in these conditions, the bidder respondent accepted this condition and as per the tender condition, 10% of the amount, 7 lakh has been 7,54,000 has been deposited. 7,54,700 has been deposited. And accordingly, he was allowed to lift 500 tons of metric tons of scrap. So in the meantime, he could lift only 250 tons of metric tons of scrap. And remaining he did not lift. So keeping in view all these the pros and cons, all these things that petitioner accepted the 200 lifting of 250 tons of metric tons and charged excise with the 10%, 5% VAT, 1% TCS. Then whatever the remaining amount that has been refunded to them. Subsequently, the respondent files the requisition bearing number 3165 on the ground that excise duty is not payable on scrap, waste and scraps. So whatever that amount that 7,54,700 what is being quantified as a tax excise duty for the 500 metric that is to be refundable. So during at the time of hearing of the case, the respondency council as well the department council is not there. So in the absence of these councils, this case was disposed. 3165 was disposed. Law points has not been properly brought to the notice of this honorable court. And this order was passed.
No, but you see, we can't encourage that, Mrs. Howe. You see, when you get notice, you don't appear.
No,
And then you say that this was wrongly heard.
no, actually in opposition object, affidavit and opposition, the law court has been discussed. That is fine, but due to some mistake, so many times I have appeared, but the day on which that was being disposed, I was absent because I could have skipped my time. So on that, so page number 17, my lord.
Because you see, there are two things. There are two judgments of this court, including division bench orders, where it says number one, for the purpose of review, you have to satisfy the court on the point of limitation. Because otherwise Article 123 would apply. So that is one point, because this repetition, this repetition was disposed of in 2015.
Yes, sir.
But this review petition is filed in 2017.
16.
16, okay.
Actually,
2016.
order was not received. Order was not received by the petitioners. So department responded took time and subsequently they served the notice and after receipt of the notice, we appeared. During that time, we are not aware that the order has been passed.
No, but it doesn't appear so.
Yes, madam. In the order itself, they have taken
If you're regarding the receipt of copy of the certified copy, if your lordships comes to page 19 of the contempt petition,
13,715.
yes,
13,715.
thereafter they have waited for another 1 year.
No,
File this.
no.
My lord, paragraph.
This
14 may
review
kindly see.
petition was filed on 26/8/15,
23/8/15, my lord.
26/8.
23/8/15.
No, 26/8.
26/8.
Yes.
But some defect, my paragraph 14 may can be seen. my lord.
Register.
So this is more or less within time.
14, paragraph 14.
Your Lordship, kindly see that whether this review application is maintainable, whether he should prefer an appeal or not. Lordship may kindly look into that matter itself.
Because Mr. Sharma,
Lordship.
uh, because you see, when it comes to the Excise Act, if the if the scrap component arises out of a capital good, then the scrap is liable to be for payment of excise duty.
But who will pay? Who will pay, Lordship? The manufacturer of the scrap, the Numaligarh refinery, they will pay,
No, nobody manufactures scrap.
Lordship. As because from the goods, Lordship, it becomes scrap.
No. You see, the the liability arises. If I remember correctly, those laws I have forgotten. The
Initially, Lordship, I am raising 2 points regarding this review application. If these 2 points goes in my favor, in that case, Lordship, matter ends there.
no, you see,
Lordship,
an excise duty is always recoverable from the end user. Supposing I have to pay excise for some reason, excise is something which is recoverable. So even if if I remember those correctly, even if the waste, if a tax liability comes and it is transferred, the ownership is transferred to someone, then excise is liable to be paid, because you see, medicine, drugs which you take, it has a component of excise duty. And those excise duty are transferred by way of the, what you call the price of the medicine. It is transferred to the purchaser, and the amount recovered contains a component of the
My submission is that, Lordship, I am raising two preliminary points. If it goes in the favor of the applicant, then Lordship, the Lordship that just now your Lordship has stated, that will come. Prior to that, Lordship, I am raising 2 points regarding the maintainability of this application and whether this review is applicable in this present order. Firstly, may I please, Lordship?
make a submission.
Firstly, if your Lordships, as because this application is not shown properly, it was not shown properly. If your Lordships comes to the petitioners, the applicants at page 2, I am raising 2 points, Lord. Page 2, there one is Numaligarh Refinery, 2 is senior manager, 3 is manager.
Yes,
Now your Lordships kindly come to the affidavit at page 12. Who is this person, Lordship? Who is this Debajit Chaudhary? For whom he has shown this affidavit. Let my learned friend answer to this query, Lordship. Who is this person? Page 12. And Lordship, if your Lordship go by the statements, the statements made in this affidavit, all the true to the knowledge. None of the paragraphs are from true to the records, Lordship. So, Lordship, in a review application, Lordship, there must be an error apparent on the face of the record. In that case, review is applicable. Otherwise, the domain of review is very limited. Whether is there any error apparent on the face of the record of this order passed by this honorable court, Lordship? So, appeal, Lordship, yes, the scope of appeal is very wide,
no, let me ask you a question.
Lordship,
You are a writ petitioner.
Lordship.
You say that the writ petitioner got service on a particular date. His service was provincialized on a particular date. And he got some benefit on a particular date. Now, on the date of hearing, you are absent. I author a judgment where I say that no,
Yes, Lordship.
the petitioner is X,
Yes,
and I give different dates of whatever event has happened. So on facts, it does not match with the facts pleaded in the petition. Now, according to you, it will be an appellate order which will be rectified in appeal, or a review would still lie.
in my humble submissions, Lordship, if there is no error apparent on the face of the record, in that case, Lordship, review will not lie. He should prefer an appeal.
Okay.
As because we are, if your Lordships go by our writ petition, the other companies like Oil India, IOC, in the selling of scrap materials, they are not claiming excise duty. Excise duty is 0. On that basis, Lordship, we are saying that you cannot claim excise duty from us. On that basis, on that submission made by us, on the basis of that writ petition, Lordship, this honorable court has passed that order.
Let me have the Sandwat rules. You have a
My
copy of Sandwat
I
rules?
provide, I go page number 6, my lord. Senate rule. Page 6, rule 3(5)(a) clause B.
Ah. You want this copy?
Lordship,
So many years I've not dealt with central excise, I've forgotten few parts of it.
Some, regarding on merit lordship may fix other day, any other day lordship, not today. But if
No,
your
you
lordship
see-
can satisfy your lordship that
No, it is a composite, you see, it can't be a placement decision, number one. If that's why I posed you that question. And number two is that if the law provides that the incident of what you call the excess liability
lordship.
would be paid, then you have to demonstrate that the order of the order of this court was correct. To ask you to ask the petition, the review petitioner to give a refund. Because the prima facie error, even without going into the facts of the case, is that whether the pleadings of the parties, you see, I would have understood that the matter is disposed of. But the stand taken in the affidavit in opposition is not at all considered. If that is considered and disposed of, supposing you are a petitioner,
Lordship
I don't hear you, but I
did not even consider the
the
affidavit
pleadings.
in opposition. Lordship.
Then I think even there is my order where it says that the review would be maintainable. Because if I don't refer to the facts correctly, if a stand taken in the affidavit in opposition is not at all mentioned. I don't know whether in their affidavit they have taken the stand or not, I don't know. I'm just recollecting few old memories I had about the Senate rules. He has produced it.
Lordship. Then if your lordship satisfied that the review is applicable in this case, in that
No,
case.
you have a ground. I'm not saying anything,
Lordship,
but
that's
you
because
see,
the Supreme Court is very much
Yes.
clear. The Supreme Court is very much that the error must be apparent on the face of the record. I am relying on judgment. I'm reading it,
no, there
Lordship.
is not one, there are hundreds of judges.
Lordship,
We are not on
But
that.
here specifically why this appeal should be preferred. May I read, Lordship? Only one paragraph, Lordship. The scope of appellate power and the review power is well defined. The power of review under Order 47, Rule 1 of the Code of Civil Procedure 1908 is very limited and it may be exercised only if there is a mistake or an error apparent on the face of the record. The power of review is not to be confused with the appellate power. The review
That is-
petition application cannot be decided like a regular intercourt appeal.
No, that is
On the other hand, the scope of appeal is much wider, wherein
Mr.
all
Sharma-
the issues raised,
Mr.
Lord-
Kama, that is why I'm asking you. I had posed you a question
Lordship,
that if on facts, your date of appointment is X,
Lordship.
which I write in my order as A. Your regularization order is at Y, I write as B.
That is apparent on the face of the record.
According to the face of record.
Lordship. But
So
if we go by the judgment passed by this honorable court in this present review application, I do not find any such apparent on the face.
No,
of
had the court considered that there is a separate rules, and then it would have decided against the review petitioner. I would have accepted it's a wrong decision. But if if that has not been put into consideration, then what happens?
Lordship, similarly, in paragraph 7 of the affidavit of opposition filed by the respondent number 1, the respondent number 1 has also admitted that as per excise, central excise law, the excise duty is leviable on the manufacturer of the excisable goods at the rate shown in the Central Excise Tariff Act 1985. In the instant case, the manufacturer is the respondent number 1. In my opinion, on the aforesaid material, the petitioner cannot be held liable to pay the excise duty in the current transaction as well.
Tara?
So, at page 16, paragraph 2, last part.
No.
Now,
No.
I'm relying on the order passed in this present writ petition.
No, in the petition, they are referring to which, the court is referring to which paragraph of the affidavit in opposition?
Paragraph 7. Paragraph 7 of the affidavit in opposition, as because it is reflected in the judgment, Lordship.
Just.
If it is 9 or 5 to 9, no, this one, right?
You see this affidavit?
Yes, Lordship, I have gone through. So the understanding of this honorable court is that, if I am not wrong, Lordship, since the subject scrap is generated out of the capital goods due to wear and tear in the manufacturing process is done by Numaligarh Refinery, and on which Canvet credit was availed in terms of Canvet credit rules, excise duty is applicable on such scrap items. So that was the understanding of this honorable court.
No, but you
Accordingly,
see,
this honorable court,
now you read this Sandwich rules,
Lordship.
that B. If the capital goods are cleared as waste and scrap, the manufacturer shall pay an amount equal to the duty leviable on transaction value.
So in my humble submission, Lordship, the manufacturer is the Numaligarh Refinery, Lordship.
Correct.
So
Correct.
they will pay.
So they will pay. this
We
will
are,
be enough.
we are the buyer of that scrap.
But you'll have to, you see that incident always travels with the goods. Can you?
Thereafter, Lordship, if
Listen,
some,
No, I understand. That would mean that if I go to the market, buy a cigarette, the cost of cigarette is, say, 1 rupee, manufacturing cost is 1 rupee. 9 rupees is the excise duty on it.
Lordship,
Therefore, I will say that, well, the manufacturer has paid 9 rupees, so I'll pay only 1 rupee. If I accept your argument, you are purchasing a scrap. I am
If-
purchasing a cigarette.
if, yes, Lordship, if your Lordship of the writ petition, Lordship, if your Lordship comes to that, Lordship. In the writ petition, Lordship, if your Lordship comes to page 18, it is a sale release order issued by the Indian Oil Corporation Limited. May I? Your Lordship has of the writ petition, page 18.
Yes.
This is the description: miscellaneous scrap materials in central store, weight 500 metric ton.
Yes.
Fourth line. Then your Lordship comes to the next, first, second, third, fourth, fifth column. ED 0%.
No. You see. Ignorance of law is no excuse. You'll have to show that the excise act and the Sandwich rules do not apply on scrap. You see, if there is a law which has been pointed out to you, that this scrap is amenable to excise duty. So despite knowing it, if you don't charge,
Lordship.
say for example, house rent.
No, regarding that point,
No,
Lordship,
it's okay. I'm just giving you an example.
Lordship.
You are the landlord and Mr. What do you call?
My friend, Lordship, Hawk, Mr.
Your
Hawk.
friend, Mr. Hawk. He's your tenant. You don't charge the service tax from him. He lives in a lavish house, pays a lavish rent. But you don't charge component of what you call this service tax. So can somebody else say that no, Mr. Sharma is not charging and Mr. Hawk is not paying? So therefore,
Lordship, this circum, I don't, Lordship, in my humble submission, Lordship, this is also a Indian Oil Corporation Limited, like
maybe-
Numaligarh
maybe,
Refinery.
you see, I'm not on that. Somebody may know the law, somebody may not know
Lordship,
the law.
Lordship, Lordship,
But the
Lordship.
question is that there exists a law has been placed before you. Now you'll have to show that despite this, what you call Sandwich rules, the scrap does not have, there's an advanced ruling somewhere or there is a judgment of any court or any court saying that divorce the Senate rules, scrap will not have an excise, is not chargeable to excise, then you have made out a case.
Whether lordship, this review application is maintainable, whether he should prefer the company should prefer an appeal. My whole
No, that
contention is that
you-
lordship, they should prefer an appeal.
I understand. I'm
And-
not saying you're wrong. But what I'm saying is that you complete the argument. If you want to do it today, you do it. If you want to do it on some other day, do it on some other day. But I'll not have a piecemeal hearing of this matter because this is otherwise a 2016 matter.
Lordship.
The preliminary issue ought to have been raised at the preliminary point.
No lordship,
But
as
now
because,
after 7 years,
no lordship, as because this, after notice of, was issued.
no, it's
lordship,
okay. But
therefore-
after 7 years to decide a matter on a preliminary issue, I'm not doing it. I'll take
In
up the
that,
matter on
if
merit.
your lordship wants to touch the, on merit,
Yes, both.
in that
both.
case, lordship, I want some time.
Okay.
Lordship may fix any other date, lordship.
You choose a date, both of you. Both of you are-
As per your lordship convenience, my friend may be some difficult, but I am always here. On 10th,
After 2 weeks, give a date.
in the first week of June, May, if it is not inconvenient. First or second week, lordship, not in the, in May,
7 June.
7 June, lordship.
Yes, my lord.
Okay.
এখন
Uh,
lordship.
Both sides are duly represented. Mr. H. Royal and H. Sharma and counsel for the respondent. In the review petition, submits that he is raising a preliminary issue of maintainability. Full stop. Considering the fact that this matter is pending since the year 2016, instead of hearing the matter on preliminary issue, the court proposes to hear the matter on merit as well, keeping the issue of maintainability open.
Lordship.
Full stop. This procedure is adopted because of the fact that this matter is pending for last 7 years on board, and therefore it is preferable that the merit should also be addressed along with the preliminary issue on maintainability. Full stop accordingly. As agreed to by both sides, list on 7/6/2022.
Machu.
You take back your. But you make a note of those, what you call,
Yes.
the law points, because I won't remember.
Yes, I.
Yes,
Item 29.
May I please, my lord? Order is complied, my lord.
complied with.
Very close, my lord.
Mr. S.K. Singh,
B. Kumar.
B. Kumar, Mr. B. Kumar, learned counsel for the petitioner, from upon instructions has submitted that the order dated 25/8/2015 passed by this court in WBC 758 of 2014 has been complied with. So, Mr. S.P. Bhattacharya, counsel for respondent number 1, is present. So accordingly, matter since closed as the order has been complied with.
Obliged.
Obliged. 32.
Item 32.
Yes, Mr. Majumdar. Here you had called the principal, but you did not comply with it. Do you have the further instructions?
My lord, sorry, my lord, the post list does not reflect anything, my lord, I missed it out.
Just look at this order, you'll understand.
Lordship will give me 2 minutes time, my lord. I may have the instruction.
Take it up after some time.
My
In
lord,
the
yes, I
meantime, you
just
find
had
out.
my request. From Kamrup Rail, something had come.
Just wait for some time. You can keep the file with you for the time being. Yes, next item.
Item 34 with 35.
In this case, has been complied with now, Lordship, after 2018 order. They are
Okay, that is
insisting
good.
that interest will be paid. No, I have informed them that there is no order of paying interest. That is why I cannot say that interest will be paid. Only pension has been released now. 2 months pension has been released.
Okay, good. At least let's come to an end.
Everything has been complied with.
Okay.
Order has been passed on 2018 also. Now
I got it, but since matters come to an end, even after 3 years, it's
Yes, Lord.
4 years,
5 years.
because I was feeling bad for Mr. Goswami appearing for such a small matter.
No, this is not
Uh,
Lordship. This is regarding pension of Lordship.
No, pension also that.
Assam University. Lordship, 3 of the petitioner has already died, Lordship, before getting pension. During compliance, 3 petitioner has died.
Had Mr. S.K. Goswami done counsel for the petitioners. First of at the outset, it is submitted that during the pendency of this petition,
No, during petition or contempt.
sorry, contempt petition, who has died?
Lordship, 2 petitioner died. There are 2 contempt petition, Lordship. Out of these 2 petitioner has died, Lordship. 7, Lordship. In 239, Lordship, 7 died. Nikunjo, Dr. Nikunjo Bihari Bishwas, he died. Lordship.
No, I have with me 219. In 219, there are 2 petitioners, they are alive.
Lordship. Yes, Lordship. In 239, Nikunjo Bihari Das died.
No,
Lordship.
just a moment, I'm disposing of one by one. I'm now having contempt case 219.
Lordship.
Here, both are alive. Okay. No, that's not required. And Mr. S.C. K. Leonard, counsel for the respondents. You're appealing for both the respondents? For the respondents. And petitioners, huh? Yes. Yes, upon instructions, the learning counsel for the petitioners has submitted that though belatedly, the order of this court has been complied with, and the first installment of pension for 2 months has been released. First one. Next for although the delay in compliance of the order of this court is not appreciated, nonetheless, though belatedly the order has been complied with, the court is inclined to close this contempt petition. Stop. Then 230. You release the amount with interest?
Yeah, no, interest has not been paid, and the interest, there is no question of any interest.
Yes, because there's an order of 512, it says total entitlement of the petitioners is rupees 694,86,397. And white communication dated 17/11/2022 made by the Assam University to the Ministry of Education. It was indicated that the amount of rupees, the amount of the employee share in 10 retired superannuated employees is 166,68287 along with the actual interest. And as on date, the amount is retained by the Assam University
That has been paid along with the interest loss.
along with the interest. Okay.
So we have not been paid interest, only we have.
No, interest will not go to you. It will go to that PF fund, PPF. The interest will not come to you. It will go to that. Otherwise,
Yes.
there will be deficiency and you will not get the PF.
Yes, Lord.
Same thing here also. Same
Yes,
order.
Lord.
Same order.
Lordship, my record, Lordship, respondent, petitioner number 7 died. Two petitioner died. Nikunjo Bihari Vishwas died. During pendency of the contempt petition. Then say what will they will get?
No. There is because somebody died. I have to record it.
has been paid to their legal assets.
No, it's okay, but
I have to inform the court that he died.
he has to do it then. Order 22 Rule 10A. And I have to record it. Here you write one paragraph you add. It is submitted at the outset that petitioner number 7, Dr. Nikunja Bihari Vishwas, has expired during the pendency of this petition.
And another person, I've informed the name, Lordship. I've informed the
Okay,
name.
okay. One more person, he will give you. Has been in the paragraph, we say that Mr. Charles says that it has been complied, it has been complied with. Add there, in this regard, the learned counsel to the respondents has submitted that notwithstanding the death of the petitioners, petitioner numbers 7 and so, comma, the legal representatives of the deceased would become entitled to receive the
Other benefit.
financial benefits. Okay, just add that.
Apply this.
Item 36.
Yeah, please, Your Lordship. Lordship will find the order dated 27/3/23, my lord.
Yes. You got instructions.
Already we have sanctioned, but
No, because now you have to give the amount, the names of the persons in the finance department who are withholding it. We'll impede those persons.
My lord, it was sanctioned, my lord. And it was forwarded to the treasury.
But treasury is not,
Treasury officer, New Chilchar, Kasar.
but he is not cooperating.
No, that's not the issue, my lord.
Huh.
The treasury, concerned treasury should have been Lakhipur treasury. It was submitted in the wrong treasury on 29/3. My lord, may I place it, my lord?
Yes.
And it has been issued by the government, my lord. They have wrongly, my lord, placed the final, my lord, sanction before a wrong treasury.
So by what time it will be rectified?
My lord, rectification now, my lord, that sanction will be it will remain valid till 31st of March 2023. So they will have to submit a proposal to revalidate that particular sanction. then it will have to be placed before the contempt result.
No, instead of that, we issue a direction to the what you call the finance and the education department to act in tandem and give the necessary, because you see,
Yes,
the
yes, my lord.
proposal will be sent
There
again.
is the procedure, my lord. We
No,
will
I
not
understand,
act
but you see, those
expedite.
procedures may take us to two thousand
No, no, no,
twenty-four.
lordship may today direct, my lord, let them, my lord, act upon it, because it is an admitted position that they have now sanctioned it. Though, my lord, the petition has not got the amount, but it was sanctioned. So since it has lapsed, my lord, lordship will see down below, my lord, serial number 6. Treasury officer, new filter. It should be, my lord, Lokhipur Treasury.
No, just a moment. Mr. Sharma, you better start including the new incumbents, put them to notice and impede them. Because you see, we can't be harsh to both Ms. Fukan and Mr. Gogoi. Since they are departmental counsel, they are not appearing for any of the parties. I find it very difficult to bind them. You file an application for impeding, because you can't say anything to both of them. They are not counsel on record.
My statement may be recorded, my lord,
Ah,
then it is
recorded.
left in the Lokhipur Treasury.
Mr. R. Sharma, then counsel for the petitioner. Ms. N. Fukan, then
Respondent 1.
counsel for respondent number 1 is present. Mr. B. Gogoi, and that's standing counsel for the finance department. Has appeared at the instance of the court. And he has submitted that although the appropriate government has sanctioned an amount of rupees 4,11,555 in favor of the petitioner towards arrear salary, but the payment order has been endorsed to the Treasury Officer New Silchar oblique Kachar, Treasury Silchar. First, it is submitted that as per instructions received by him, the appropriate treasury would have been the Treasury Officer, Lakhipur,
Lokhipur,
Silchar.
Silchar.
Full stop. In the said context, it is submitted that in view of the error, the authorities in the Department of School Education will have to resubmit a fresh proposal by indicating the paying authority to be the Treasury Officer, Lakhipur, Silchar. Next paragraph. Next paragraph. Having regard to the fact that the respondents may not be in the office at present, may not be holding office, their respective offices at present. comma, the court is inclined to grant liberty to the petitioners, to the petitioner to serve, to put the new incumbents to notice about their requirement to comply with the order of this court and file an appropriate application for implementing the present officers in this contempt proceeding. Full stop. The learned counsel appearing for respond number 1. Comma, in the meantime, tell. Instruct the respond number 1 to convey the order of this court to the present incumbents to office. Next paragraph. Here's by what time you will file an implementing application?
Within 2 weeks, my lord.
So does this matter along with the after 3 weeks and or as and when the implementing application is filed? Next, by the instructions produced by the a copy of the sanction letter dated 17/3/2023 as produced by the learned Standing Counsel for Finance Department is written on record. Okay. You see, Mr. Sharma, this is the difficulty. If the new incumbents are not in office, we can't enforce the orders. Even if you want to send a message, you can't do it.
I'll file it.
37.
Yes, Mr. Malagar, we had put a, we had spoken our mind in the order dated 3/4/2023. You have to say anything?
No, my lord, it is too late, my lord. He is waiting for the salary. He says others. That is why it is, late. I may kindly be considered the other to pass it.
Because I told you last occasion also, we'll have to close your contempt petition because this is something we can't do anything. In the contempt petition, you have only implicated the director. Director can't do anything.
No, but
Unless-
he is the appointing authority. That is why he had appointed the person concerned. He is appointing authority
Okay,
and
Mr. Malakar, I gave you a fair opportunity, but you are not doing anything. I'll dismiss your petition.
the appointing authority and the responsible person. That is why he is given this answer.
I understand.
Ah.
I am sitting here as a responsible person.
Yes,
So therefore, any file which is lying in the registry, I'll pass orders there. Correct?
yes.
Without being listed before the court. I would go to section and section and pass orders and come again. That is what I'm supposed to do, right? As a
Yes,
judge, what do you expect of me? As a judge of the court, what do you expect of me? Since I am a responsible person, I'll walk in the corridors of the High Court,
Yes, my lord.
take out, go to section and section, take out the files and start disposing of orders in the section.
I shall give you another five.
No, Mr. Malakan, I'm asking you a question.
Yes.
I'm talking of something which is responsible. I take the responsibility. I claim that I am a responsible person. Maybe right, may not be right. But as a responsible officer of the court, what should I do? Should I dispose of matters which are listed before me? Or I should move in section and then dispose of whatever comes in my way? What should I do?
I shall,
So you expect the director of elementary or secondary education to give you salary when the proposal is not even sent by the principal. Very responsible person. So he'll go to school, find out from the diary whose proposals are to be sent, whose salary is to be paid, and then start his office at the site.
Another thing, I shall give all the details of all the concerning officials. Three
Okay,
officials
then I'm
concerning-
dismissing it, Mr. Madakar.
No, another date is given, may be.
No,
kindly
you see,
considered.
giving dates is not possible, but I can't make you understand anything.
Yeah, but-
If you don't understand with examples,
but the inspector, principal and director, these three persons, officers are connected, but the responsible, main responsible is director. Yet then, the person, the responsibilities of each of the officers, I shall give in the next, I may be kindly allowed. And for another.
no, I know the responsibility of people. I'll note that. Don't worry, I'll record your statement. But still, I'll be
Details-
dismissing it.
Obtaining the details for records. And
In my order, you'll find whoever is responsible. I'm giving details of every people who are responsible. But whether a case of contempt has been made out.
No, the three persons, between the three persons, but main authority is this director. But
I understand. I'm not disputing your statement at the bar.
Yes, sir.
I respect your statement.
Yes, ma'am. No,
With-
no,
with-
they did,
with- With all respect to your statement, I am dismissing it.
no, my lord, the thing is the three persons concerned in the in the matter. But the inspector and principal also responsible, but the main responsibility is in the director. But for giving the details, all everything. Another that may kindly be allowed, I shall give.
No,
that detail.
Mr. Malakan, I'm still dismissing it. I can give you a hint, but I can't make you understand. Heard. You see, last time I saved it because of the fact that last time I did not dispose it of, did not dismiss it. Thinking of the man behind this petition, it is the petitioner who is be losing. So therefore, I formulated this question and then I adjourned the matter. Today, you are on the same place where you started, number one. Number two, even if you try to rectify any of these defects, you see, under section 20 of the Contempt of Courts Act, the limitation is 1 year. Today, you can't impede a new person and say that he has committed a contempt. Therefore, even that fact did not occur to you. You are merely saying that you will bring the responsibilities of the officers on, you will inform us about the responsibilities of the officers. Responsibilities we know.
Yes,
In the contempt petition, we are not adjudicating on what responsibility people have.
yes, ma'am.
We are adjudicating whether the order of the court has been complied with or not.
Yes, ma'am.
But director is not expected to pass orders of salary when the principal you exonerate the principal, who is the person who makes the bill. Once the bill is not made and sent to the director, how will the director make payment? That's why I pose you that question. As a responsible officer of the court, what should I do? Should I concentrate on the board and dispose of the matters? Or I walk from section to section and take out files and I start disposing it off? A director is not expected to go to school, find out what salary is done, what is made, how much payment is to be declared. Proposals are sent for that purpose only. A director is only one in the institution. He can't work alone. So since you have exonerated the principal, I am dismissing your contempt petition.
Well, the party is so suffering that he cannot even come to the this place that
Mr. Malakar,
because of that.
I told you, I don't disrespect whatever you are saying.
Yes.
But this court has passed a judgment long back, saying that under circumstances, even a clerk can file an affidavit. This is not, this is authored about 25, what do you call, 30 years ago. There's a judgment of this court saying that even clerks are permitted to swear an affidavit.
Well, I shall give, I shall try. Very safe.
But you can't improve it. Mr. Malakar, can you improve it? Can you implead now anyone who's not a contemner, who's not a successor in office? You can't do it.
Well, I shall give everything from the principal, inspector and director. All three, the responsibility. I shall-
Mr. Malakar, have you understood what I'm trying to convey? I have posed you a question. I have asked you, can you now implead somebody who is not, whose office is not impleaded as a contemner earlier?
Yes, definitely.
You can do it. Under which provision?
Yes.
What about section 20? Limitation is 1 year.
Modern or the current.
Then you can't do anything about it.
Sir,
We gave you an, we
for
gave you an
the-
opportunity to
try
tell us.
To save the.
We gave you an opportunity.
Of the.
You see, you don't, if you don't read the orders which I am passing, what is the point in adjourning the matter? In the last occasion, I took the trouble of writing the order dated 3/4/2023, where I have specifically noted this. In this contempt petition, there is no document to show that the principal of the concerned college had forwarded the proposal of arrears salary of the petitioner to the Director of Secondary Education, Assam. In this contempt petition, annexure A1, A2, A3 are the representations for arrears salary. However, there is no document to show that the bill or proposal for the arrears salary was made by the principal of the school. And in the contempt petition, only director has been impleaded without adding any concerned person by name. So there are not one, there are several defects here. Can I proceed in a contempt against the office?
No, my lord.
Then I gave you a reasonable opportunity.
I had given being the.
Mr. Malakar, on that day also I spent 15 minutes with you. Today also 15 minutes. I could have, I'm asking Mr. Barbuya to wait, expecting him to, his matter to be taken up. I can't devote so much of time when I can't make you understand anything. Heard Mr. R.K. Malakar, learned counsel for the petitioner, and Mr. S.P. Bhattacharya, learned counsel for the respondent.
Another sons may be given if possible.
No, it's always possible.
For collecting this information. That is.
It is possible, but can you improve it?
Maybe it would be possible. A time may be given. I shall try again.
The Mr. R.K. Malakar, learned counsel for the petitioner, prays for adjournment. Mr. S.P. Bhattacharya, learned counsel for the respondent, is present. Next paragraph. To the points narrated in the order dated 3/4/2023, at the present, the learned counsel for the petitioner has no answer. Full stop. He submits that he, however, he prays for time, so prayer of adjournment is allowed. This after 4 weeks.
Item 38.
So 38 is adjourned. 38 is there for adjournment is made. 38 mentioned.
32 time being.
Okay. 32,
But this,
you got the information?
my lord, the district office tells me that these bills have all been paid. But I won't even writing, my lord, because I'm in.
It has been paid.
The areas have been paid, my lord. It was put forward by the school. Forwarded by the district authorities. Nothing pending showing in their records.
I'll still, my lord, I'll take a week's
Okay.
time, my lord, I'll just bring that.
Y-
on
y-
the
Your
barracks.
name? Your name?
My lord, my name is Miss Korobi Saikia, K Saikia.
Okay,
Korobi
Ms.
Saikia.
K. Saikya, counsel for the petitioner is present. Mr. R. Mazumdar and standing counsel for the elementary education department submits that though he is not the engaged counsel for the respondents, but he is appearing as per direction of the court dated 17/2/2020. Full stop. It is submitted that as per instructions received from the district elementary education officer, the amount due to the petitioner has been paid and full stop. It is submitted that he has asked the officer to provide with him with a copy of a document in the copy of the relevant document. And accordingly, he prays for some time. First of all, prayer is allowed. How much time?
10 days time, lordship will give. Because once he gives something, I'll have to confirm with the.
10 days.
Also.
So we fix it on 15 then,
Yes, my lord.
list on 15/5/2023. He's paid, you just ask your client also.
Lordship, yeah, he's suffering from illness, from reliable source, I come to know.
No, but
But
if it has been paid,
Okay.
you can just inquire. Illness has nothing to do with that. Mr. Mazumdar is saying that he's been paid, nothing is due.
Yes, I'll. Oblige, Lord.
Yes, 39.
Item 39.
PDF will. Phone number, sir. He does it. He does it. Yeah.
Last order says that the amount does not include dues payment to the Baksa Junior College.
True, my lord. My lord, I have got the matter clarified from the. What has happened is this, the payment to the Baksa College is to come from the Department of. It is called,
School education.
no, Department of Welfare of Boroland.
Okay.
They sanctioned the money. Therefore, my lord, we could not sanction it at that point of time. There was some misunderstanding between me and the department. I could not place it properly. Lordship, that letter that I have now placed, Lordship will find. Para 1, with reference to the subjects at above, I am directed to inform you that salary area matter of educational institution under the jurisdiction of BTC is dealt by the BTC and Welfare of Boroland Department, Government of Assam. Therefore, the matter relating to release of areas in respect of teaching and non-teaching staff of Baksa Junior College, so and so falls under jurisdiction of Director of Education. As such, this department has already requested the Director of Education BTC.
But if the state has a Department of Welfare of Bodoland Department,
Yes,
how does the public benefit of it? It's a department for welfare of Bodoland Department. So you create one department for the benefit of
Welfare of Boroland.
welfare
Department.
of another department. How does the public benefit out of it?
One of the departments should be missing, well.
I don't know. I don't know. I'm just reading what you have said.
Yes, well, that is how they've written. Lordship will find the 4th paragraph. However, during this financial year, the Director BTC in his report has stated that BTC has already submitted the demand for fund in the online mode to the Principal Secretary of the Government of Assam, Welfare of Boroland Department. The budget provision in the Department of Welfare of Boroland is stated to be 50 lakhs. Balance requirement can be demanded and brought as supplementary demand by the BTC and Welfare Department. It is therefore requested to kindly apply. So that money has to come from another department. We do not sanction it as such. Department of WBT department of that has now become Department of.
No, this department at the end is wrong.
Yes.
Two departments makes it a wrong reading. It should be Department of Welfare of Bodoland.
Yes, Department of Welfare of Boroland. Otherwise, he may be able to go. Hassan. The department has a standing council, my lord, perhaps Ardhar. He may be able to throw some light. Hassan,
No, not Aadhar. Aadhar is a BC, maybe, what do you call?
WPTN, we said now has become this.
WPT department and now has become.
Welfare Plain Tribe Development, the WPTN
No,
BC.
but this is a contempt petition. I find it very difficult to ask the standing council to appear.
Otherwise, my lord, everybody has done their part in this, and the contempt petition would not survive, the contempt would not survive perhaps, unless they make someone a party. Or unless this honorable court takes the view that Department of Welfare of Borland is not, is causing a hindrance in the complete.
I don't say, I won't make any comment, but I just record this, what you said. Can you say this, what do you call the funding
My lord,
by this BTC
yes.
has started since when?
That, I apologize.
Yes.
Lordship, on the last occasion, Lordship had asked us to file a implement petition application. But it was
I normally would not ask you.
directed us, Lordship.
Lordship may like to have the sixth page, my lord, it's a letter by the director of BTC at dated 24th of April 2023, the bunch that I have given, my lord.
No, you see, here is also the same situation as was there in the previous case. You are Mr.
As Gautam.
S. Gautam. Mr. Gautam. I hope you were there when I was interacting in the previous case.
Yes, sir.
You were there in the court. Now, in this case, you see, they are now taking a stand that it is the BTC who is the paying authority. In the rate petition, BTC Principal Secretary was one of the respondents. But this, you have exonerated him, you have not proceeded against him. So therefore, we can't issue any direction to the BTC to do anything at this stage.
Lordship, if Lordship allows me to give me 2 weeks time to seek instructions.
Okay, I'll just make a note. I'm not saying anything, but I'll make a note. Mr.
As Gautam.
S. Gautam, counsel for the petitioners is present. Referring to the order dated 24/3/2023, passed by this court, the Mr. R. Mazumdar and counsel for the Secondary Education Department. Has submitted that there was a communication gap between him and the Department of School Education within bracket secondary. And accordingly, on seeking appropriate instructions, he is in receipt of Uh, Communication dated 25/4/2023 from the Department of School Education. Informing him that the Director of Education, BTC, had submitted a report dated 24/4/2023, stating the reasons why the area salary could not be disbursed during the previous financial year. It would be relevant to quote the contents of the said letter dated 24/4/2023. Pink flag. Full stop. As per the next para, as per the said instructions dated 25/4/2023, the BTC authorities had submitted a demand for fund in the online mode to the Principal Secretary, Government of Assam, Department of Welfare of Bodoland, full stop. The budgetary provision in the Department of Welfare of Bodoland is stated to be 50.00 lakh, and that the balance requirement of fund can be demanded and drawn as supplementary demand by the BTC and the Department of Welfare of Bodoland. Full stop. Next, in view of above, for the matter stands adjourned today to enable the current counsel for the petitioner to take appropriate instructions. List after 2 weeks. Okay. This correspondence you take after some time, let him put it, you'll get it tomorrow.
I have another copy.
You'll get it. Yes.
Item 40.
Item 40, my lord. Challenging the compliance order, the WBC number 1658 of 2022 has been initiated by the petitioner. We had passed the compliance order, and
Okay.
that has been challenged in WPC 1658 of 2022.
Oh, okay. None appears on call for the petitioner. Post of Mr. R. Mazumdar, standing counsel for the. No, sorry, then counsel for the respondent has submitted that during the pendency of this case, the authorities, the authorities in the Elementary Education Department has passed an appropriate order in compliance with the directions contained in the order dated 12/12/2018 passed in WBC 8-5 of 2016. First off, it is submitted that the orders were passed by the authorities being unfavorable to the petitioner. The petitioner has assailed the same by filing a writ petition, which is registered and numbered as WPC,
1658 of 2022.
which is pending. Next paragraph. As the petitioner is absent on call, the Foreign of Justice, the matter stands adjourned today. However, the petitioner remains absent on call on the next date, appropriate orders will be passed. Yes.
41.
Item 41, I had given an email received from the college authorities. The petitioner has expired. He had the orders were that we were required to pay any arrear salaries if were due to him. And all arrear salaries were paid in his lifetime. He received subsistence allowance during his lifetime. And now we have also processed his compassionate family pension as required under the rules. That matter I had given in an email that required document.
Okay.
Petitioner has
Got
expired.
the email. None appears on call for the petitioner.
Email passes.
First off, Mr. R. Mazumdar, learned counsel for the respondent number 2, correct,
Yes, college.
has submitted that as per instructions received by him, the petitioner has expired and that during his lifetime, he has been paid the arrear salary and the subsistence allowance. First off, it is submitted that on his death, the departmental authorities have also processed the file of the petitioner for compassionate pension, family pension to his surviving family members in terms of the scheme of the state. First off, a copy of the said instructions is retained on record. First off, for ends of justice, the matter stands adjourned today. First off, if the petitioner remains unrepresented on the next date, appropriate orders will be passed.
The death certificate also they have given.
Instruction along with death certificate. Okay.
Obligation.
This contempt matter, since the petition is not there, I'm adjourning for a day. Yes. 43. Review,
Item
I'll not
43.
have time to hear today.
My lord,
I'll post it some other day.
my lord. They're also supposed to file affidavit, my lord, the office note. They were supposed to file affidavit
Who?
in opposition, the other side, my lord.
You filed it? No.
No.
Due to both sides are duly represented, due to positive time, the matter could not be taken up for hearing. Accordingly, matter stands adjourned today. List on. We'll give another date on the matter. Liberty is granted to the respondent to file an affidavit if so desired.
12th of May, 12/5.
12/5.
Obligation.
Yes, 44.
44.
As per last few orders, but I have filed an additional affidavit matter annexing the admit card of domestic, showing his father's name. My lord, curiosity, my lord, page 35, my lord. Page 35 of the additional affidavit, my lord. This is the admit card of the petitioner, my lord, the HLC examination.
Yes,
my lord.
elementary education. This, you have filed what?
Additional affidavit, my lord, annexing the metric admit card, my lord, showing his father's name correctly, my lord.
When did you file
Page
it?
35, my lord. Page 35, my lord, it.
Page 35.
Additional affidavit, my lord, continuing, my lord. Page 35 in additional affidavit, my lord.
No,
It is
additional
a
affidavit.
continue, it is continue from read petition to the additional affidavit, my lord. In additional affidavit, my lord, though it is, my lord, only 3-4 pages, but it is continue, my lord, for it is, my lord, 35, page number 35, my lord. Federal Russian Court, my lord. Anything else, my lord? May I supply?
No, it's not there.
May I supply my one copy, my lord?
No, it's not there on record because if I'm passing an order, I have to, it has to be on record. It's not there.
It is earlier date, my it has comes, my lord. But anyway, my lord. If not comes, my lord,
Just check up. Just check up.
let it be, my lord.
Just check up.
Third
I'm
date,
not
my
finding it. Just check up.
Take them to high court record.
Yes, item 45.
Item
35.
45.
Page 35. Yes, Miller, I am for the applicant. This mistake has been filed. Because the contempt is 139-18 has been dismissed on 24/2/23 for non-representation by the
No,
applicant.
this has to be heard. Mr. Mazumdar,
My lord.
and anybody else who can assist me in this matter. You see, what has happened, this contempt petition was dismissed. And what this court did was, the petitioner was absent on the previous date and even on that day, and therefore it was dismissed for non-prosecution. And then the notice of contempt issued on the respondent earlier on 4/4/2018 was recalled.
Record, yes.
Now with the recording of the order, that means the what you call, the initial process itself has been recalled.
Yes.
Now, what will be the effect of this order and read with section 20? What will be the effect?
Content is still no, সেইটো মই জানো। Time to pass over. 2018 content আছে। At least আজি দিলে time নেই।
You have to make your submissions on law because I don't know, we're not very sure. This is something I never contemplated. What does section 20 say?
20 my lord,
No court shall
initiate any proceedings of contempt, either on its own motion or otherwise, after the expiry of a period of 1 year from the date
Yes.
on which the contempt is alleged to have been committed.
Yes. So if the initial notice is recalled,
Recalled.
that means the process itself, anything initiated has been negated.
Negate.
So today, if I issue process,
Afresh it,
Today, if I'm issuing process, it will be hit by section 20.
Had it been within the time frame of 1
No,
year.
If
and
that
it could have-
notice was not recalled, then initiation was done.
Hmm.
And therefore, notwithstanding that it has been dismissed, it could have been restored and
Restored.
taken.
With the recalling, it will not.
I don't know, that's why, since I'm not very sure in this understanding.
So we'll fix a date on this, my lord. I'll try to
Try to have the law on this.
find out.
You are Mr. L. Kalita.
Yes, my lord.
You have understood what I'm trying to ask you.
Yes, my lord. Lordship recall the order and by recalling the notice.
Why I don't really, I not have the power to do it. That's why I'm asking the question. So don't say yes when I'm asking you a question. You said that you understood.
Hmm.
If you are not understood, try to understand it from me. But if you say you have understood, then I can't help you. Mr. L. Kalita and counsel for the petitioner.
But I have filed this case within time, my lord. And
We can't help it.
Your lordship has jurisdiction to restore it also.
I won't have jurisdiction. That is why the question is. This interlocutory application has been filed for restoring the proceedings of con case C 21 of 2023. No, sorry, this is 139 of 2018 to file, which was dismissed by order dated 24/2/2023. Next para. It appears that a question of law would arise in this case. Next para. Arising case, which is as follows. Next para. This court, while dismissing the proceedings of con case C 139 of 2018 by order dated 24/2/2023, proceeded to recall the notice of contempt issued upon the respondents of the contemners earlier on 4/4/2018. Stop. Just give me that book. Thank you. Stop. In view of the said provision of law, in view of the said order, comma, if the provision of section 20 of the Contempt of Courts Act 1971 is read, comma, the prescription of law is as follows. Quote section 20. Next paragraph. Therefore, comma, from the provision of section 20 of the Contempt of Courts Act, comma, once the initial process has been recalled, comma, if any fresh notice is issued to the respondent contemners, whether it would amount to initiation of contempt proceeding beyond the period of limitation prescribed. Or whether it is permissible to save the initiation of contempt proceedings merely by recalling the order dated 24/2/2023 passed in con case C 139 of 2018. Next, on the question as indicated above, the learned counsel for the petitioner, for the applicant, shall address this court on the next date. Yeah, listing it on Wednesday, 10th May. You make your submission on that day. Yes, Mr. Mohammed.
Yeah, I have seen that is not tagged with the application.
It's not
May
there.
apply on Friday along with the
Okay.
additional application.
List this, you want on Friday.
Yes, ma'am.
Friday is our off day, 10th May.
Along with the
Uh,
additional application. Oh, we have filed it may
List-
30th of March.
This matter, along with the purported affidavit filed by the petitioner on
On 38th of March.
3/03/2023. Okay. 10th.
Item 46.
Yes, Mr. Barbuya.
Your lordship, if your lordship are rising melody, you cannot.
How much time you will take?
It'll take at least half an hour to 20 minutes to half an hour. May I pay one thing, my lordship, takes the case any day, Tuesday, Thursday, fixing at 2 o'clock,
At 2 o'clock I won't fix, but you make a prayer, we'll upgrade it.
my lord, because I'm going to retire in the month of December, my lord, and I'm hesitating right from 2016, my lord. My promotion was not being given one on the other pretext.
You see, only two questions
Lordship,
to you. Number one, if I have understood it correctly, if I am reading alone, I don't know whether I have understood correctly or not.
lordship,
If I have understood it correctly, the only impediment in your promotion is the absence of any draft rule.
my lord, draft rule is there, my lord. Draft rule is there, and they have given my
No,
lord,
sorry, draft rule which has not been published.
not published, but it has been, consent has been given by the judicial department, law department, and other department also. To that
No, but you
effect,
see that consent won't make it a what you call that aspect.
my lord,
Oh.
to that effect, my lord, I relied upon two judgment, my lord, maybe in the case record, my lord. One is, my lord, if the draft rule is there, my lord, it can be acted upon, subject to the condition that the government has given due approval. That your lordship will,
No, it's not there.
or next day, I can submit, my lord,
So that is the only point.
on the point, my lord.
That is the only point. I don't think it will take any time. Are you ready on that point?
Any other time, my lord, because time, I think time will not permit.
No, time is not considered because that is the only question I found in this case. If that is when you are prepared to answer it, I think it will not take more than 10 minutes in the matter. Because if you are not prepared, then we'll adjourn it.
Mr. K. Google will do it. I have asked the junior to call in the cases.
Okay.
And as the records is also there, madam. Lordship fix, if he is not, my lord, arguing today, my lord, lordship fix the case any day, Tuesday, Thursday.
Okay. Tuesday
Two Indian nothing.
is a pattern matter,
Two
election
months.
matter. Just check up.
Tuesday, no, that
Oh.
online.
11.
Indian account.
11th May.
Both sides are duly represented. Due to positive time, matter could not be taken up. List on 11/5/2023.
Lordship, if possible, my lord, lordship.
You make a mention, we'll upgrade it.
Lord-
Because you see, I have to complete the orders and then start
Lordship,
hearing.
lordship,
The difficulty is that,
lordship.
but if I've understood it correctly, if that is the only point involved,
That is the
we'll
only
hear it.
point, and to that effect, some judgment, two judgment, I got it, other judgment also I'll bring in.
Okay. Okay, item 18.
Item 18.
Record was called for.
This is higher education. Mr. Gogoi is coming.
The records are here, my lord.
No, item 18.
Item 18.
18, my lord, yes.
Huh.
The records were called for, my lord. Records were there, my lord.
Yes.
If I can place my lord.
Just show me that. I'll have to fix it some other day, but I just wanted to say something.
The enquiry report will reveal everything, my lord. Uh, I just wanted to ask you. You are Mr. SK Das.
SK Das. Mr. Das. If I have understood your stand correctly, you are assailing the departmental proceedings,
My lord.
amongst others on the ground that prior to suspension, you are not given any notice, right?
My lord.
That is the only ground.
My lord.
Or you have some other materials to challenge it.
Some other materials. My lord, disproportionate. This is the main punishment should have been,
The allegation is that the file was missing.
my lord.
The allegations is that he is not cooperating in the
Five charges
class
was
matter.
there.
He argued with the principal. The allegation saying is the petitioner stat matter that he could not perform well in college matter. He argued with the principal. He misbehaved with the staff and all matter. Those are the allegations matter. It will find matter 31 matter 31 page number 31 of the petition matter. The
No,
order.
not that. No, I'm just trying to understand the case is made out. But Mr. Das,
My lord.
subject to what you say, the first ground which I have said is that as I understand this, the allegation is that a prior notice was not given before suspension, number one. Number two is that the non-participation is on the ground of illness,
My lord.
correct?
My lord.
Now, how have you sustained this allegation of you being ill? Did you inform the authorities that you were ill and that they disregarded that?
No, my lord.
No.
No.
Then what you call, we can't even enter into the question whether the proper procedure has been adopted. You see, to challenge a disciplinary proceeding, there are certain parameters.
Hello.
Can you satisfy any of the parameters which are required to assail the departmental proceeding?
Only ground is that the this punishment is not proportionate. So department should have been deduct the salary or increment, stoppage, the increment,
No, you are an assistant professor. Correct.
my lord.
If you don't, if the allegation is that you don't perform well, merely by deducting your salary, your performance will go down again. You see, every person in his life must have faced the situation where some of the teachers are excellent, very good. Some of the teachers may not be so good. And there are some teachers on whom the students do not want to comment. Giving respect to the teacher, they don't want to comment. So therefore, if a assistant professor, there's an allegation that he is, I think, unenthusiastic in taking classes, then you are irregular in attending classes, non-cooperative with departmental activity, smoke in the college campus. Because I really don't find anything positive to even think that the
Although this charge is there, 5 charges is there, it should have been proportionate, constant. The harsh punishment may be imposed by the department.
So what can one do about a assistant professor? You can't make him you can't downgrade him. Once he has earned that what you call status of an assistant professor, he can't be downgraded to a lecturer. The bringing down his pay scale. Mr. Das, we all have experiences with education. I won't name the name of the school, but one of my very, very close relation had gone to a school and when I call up on a Diwali day, my son was not, it's come out, it's my son. My son was not picking up the phone and I was annoyed. Diwali day, parents are wanting to call him and wanting to talk to him and he's not attending his phone. Something very unpardonable. So I was furious about it. I spoke my mind left, right and center without hearing him. And then he says that, okay, please hear me. I said, yes. He says that I was in class. I said, no, Diwali day you are in class. Don't tell me that. He said, no. In my school, the temperament is that in the Diwali morning, you have nothing to do. You are in a hostel. It is only in the evening you enjoy. So today evening, there is a holiday. And tomorrow we have a holiday. Since we will be late, may not sleep well. So next day when it's a working day here, the son was having a classes, he was having an off day. So that is their theory. And I found that the teachers were taking their classes with full enthusiasm. And when it comes to me, if tomorrow is a holiday, the temperament to do work comes down. Since tomorrow is a holiday, the pressure is less. So I tend to what do you call, be at ease when it's a holiday. But can a teacher be allowed to do that? Be complacent? When it comes to teaching, because it's a career for so many students. Okay, we have to answer it. These are the only queries I have in your matter. Take it up some other day. I don't have time today. Both sides are duly represented. Due to positive time, matter could not be taken up today. Yes, Mr. As Das Leonard, Counsel for the Higher Education Department, appearing on behalf of Mr. K. Gogoi, Standing Counsel, is ready with the records of the departmental proceedings. To stop. List on, give a date for hearing.
$19,500 after 2 weeks.
Placement.
My lord, can it be any other data except 19, my lord? 19, I have some problem with.
17. 17,500. Good. Ravindra, এই এখানে কিবা এটা পইচা আছে কিবা এটা সহায় কৰি দিব আৰু চাই ইন মানে কুলিটো লাষ্ট টাইম